I would not have troubled your lordship because of the endorsement in bylord's list. But I really cannot wait because my writ petition will become frustrated. I just indicate, I have been granted a lease by the government for quarrying sand on the river bank. There was a notice to show cause. We responded to the notice to show cause, no punishment inflicted, no proceeding thereafter. But I am not being issued challenge. I was waiting for the matter to be called. Now, lease is going to be expired by a flux of time towards the end of May or beginning of June of this year. It appears that I have 2 months still. But I was given an opportunity to a particular quantity of sand which I cannot do in a day or two. I need at least 1 or 2 months of time. I have paid the entire several lakhs of rupees.
Come back immediately after I come back from the circuit. I'll consider.
Wait, I'll do that.
Grateful. Mentions, regarding this, the land acquisitions has been acquired by the
Please do
government.
not mention any matter except a restoration,
No.
correction, etc.
No, matter
application,
matter
nothing
as
else.
hearing was concluded.
Have you seen the list, sir? The first page of the list.
No,
Have
only
you seen the first page of my list?
not only mention
What are you mentioning?
the matter to be disposed of. Hearing was concluded.
First page of the list and then come.
I mentioned on quantum application.
Wait for some time.
Application. Quantum application. Not in compelling circumstances. I am mentioning a matter on
I am not allowing mentioning
20th.
for the
Your Lordship, kindly hear me. 20th March 2024. My Lordship heard the matter. Original matter appearing under the heading mention matter.
Sir,
And
just what I've said, you've heard. I will not include anything in the list now.
no, I am not including matter. It is appearing in the list, but unfortunately, it is in motion instead of mention matter because it was appear and mention matter under the heading, and your Lordship was heard and was supposed to be added on 9th April. But 9th April appeared, but under the heading motion instead.
See, wait for some time. Let me see. Yes, call the raise.
Under compelling circumstances, I'll have to mention this. Why, I am kindly have a look. Taking the advantage of the interim order, taking the advantage of interim order, 4 bighas of wetland being filled up. My lord has directed matter to come on 6th May 2024.
Yes.
Kindly see, they are filling up the entire water body.
It will abide by the decision.
BDO has issued notice, BLLRO has issued notice, chairman has issued notice. They are not listening. Kindly have a look.
Chairman, they are so helpless that they cannot take further steps. Only issuance of notice.
Difficulty is since there is an interim
What
order.
is the interim order?
We cannot go and stop them.
What
We
is
cannot
the interim
get
order?
inside. And the interim order was granted initially by Justice Vivek Chaudhary.
Yes, what is the interim order?
Interim order, exact interim order, I do not have at this moment.
Please show me the exact interim order.
Suppressing all facts, my lord.
It has been extended from time to time.
Yes.
And the 20th July notice, what is this notice about?
To stop the filling up of the water body. It's a 5 bighas pond.
This is one single notice which has been stayed.
Yes. Thereafter, if I enter inside that premises, they are seeking that we will file a contempt against you. Previously they tried, they gave an undertaking before the authority. All these facts have been suppressed in the writ petition. I have used evidence in opposition. There I have divulged previous proceedings, previous 4C notice, 4D notice. They are undertaking everything. Now they have not used any evidence in reply. What they are trying, in the meantime, they are extending the interim order and they are going ahead with
Give the number. Give the number. Put a name. Yes, item number 1. You are appearing?
My lord, I am for the,
Correction necessary.
my lord, in the next page, my lord, in the page 2, in the bottom portion, my lord,
Second
since no affidavit is invited,
Yes.
but my lord, in this matter, my lord, pursuant to the order dated 7th July, 16th August, 7th July, 16th August, and my lord, 7th July 2021, the affidavit has been exchanged, my lord. First, my lord, kindly see 7th July
Are they affidavits or are they reports in the form of?
affidavit in opposition reply. 7th July 2023, my lord, kindly see. Seventh July 2023. Affidavit in opposition used by the state respondents is not in the file.
Yes, it is not in the file.
No, my lord. Apart from that, 16th August 2021, my lord, affidavit in reply has been filed by us.
So this line needs to be deleted.
Like
That is
to
what
be
you-
deleted, my lord.
Let that be deleted. Inadvertent error has crept into the order passed on 13th March 2024. In the penultimate paragraph of page 2 of the order, comma open colon, since no affidavit is invited, comma, the allegations contained in the petition are deemed not to be admitted, inverted comma close, exactly line to them, be deleted. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 13th March 2024, urgent certified website copy.
Deeply obliged, my
Next. I think number 2. Yes, anyone appearing in item number 2? None appears for the applicant petitioner. The matter is adjourned for the day. There's a resolution, I think, too. Item number 3. Same order. Item number 4.
But it is to be filed.
Lordship, I am appearing for the state respondent. Lordship.
My lord, Section 10 subsection 1 of Act 1964 is the subject matter of challenge. Due to lack of jurisdiction, you also know that the highway authority has been defined in section 3. Now, the highway authority has to be notified in the Calcutta Gazette notification. Otherwise, he has got no authority to issue notification. Here, there is no Gazette notification so far the highway authority is concerned. Now, section 10 subsection 1 notice has been issued. Kindly see the page 23.
Should go back to the non-commercial division.
Lordship, may it be taken up on Monday, Lordship. I'm led by Mr. Dhar. And Lordship, there has been an application filed for addition of party of a different writ petition, Lordship.
In this matter.
Serial number 4.
I am Mr. Guchai, my lord, due to my personal difficulty, my lord. I am not in a position to appear before the court today.
Mr.
I have
Guchai,
also
for
filed
whom are
an
you appearing?
I am appearing for the petitioner, my lord, when I should be added as petitioner in the instance case.
Sir,
Because in my instance, one of the case was started.
You filed an application for addition of party.
Yes,
Addition of
Lordship.
party, my lord. Additional party that is pending with your lordship.
Let it be
Because
not
I
today.
want to, ma'am, your lordship kindly keep it not today on Monday, my lord. I will do.
I'm good.
Not today.
Grateful.
Grateful to you.
Lord, item number 1, which was passed through, I have just had.
Next. Item number 5.
I am for the statement. I'll adjourn for a week. They are not appearing. I have not received the instruction in the meantime. I'll try to get the instruction.
None appears for the petitioner.
No, I'm for the
Will
petition.
it-
It is appear. Kindly 1 week's time may be given.
So you have to come back next week, not possible. Come back after because I just have 1 week in hand. Come back after the return. On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th May.
Deeply.
Next.
9th May.
Item number 6.
6 also, my lord, I am for the petitioner, my lord. My lord, on 9th May, my lord.
Respondents,
I don't have the brief today, my lord. That's the difficulty, my lord.
the affidavit of service is also not there. The same date.
Same date, my lord.
None appears for the respondents. Let the matter appear under the same heading on 9th May 2024.
Grateful, grateful.
Next.
Item number 7.
I am for the statement.
My lord, I am for the petitioner, my lord. This is the recorded of petition, my lord. My lord, this is the recorded of petition, my lord. Honorable Justice, already, lordship, your order, my lord.
Please switch on the microphone.
No, sir. My lord, already Honorable High Court also passed, my lord, order.
Take the microphone to your mouth, madam.
My lord, annexure, my lord, P4, my lord, page 40, my lord. Lordship, your order, my lord.
Page 40.
Yes, my lord.
Yes.
My lord, this is the recorded of earlier writ petition, my lord. My lord, the order was communicated, my lord, with the representation, but the Solomon order cannot be complied as does not fall within the jurisdiction, my lord. So, my lord, my lord, so, my lord,
Let
for
us
the-
submit. Yes.
my lord, further representation file, my lord. So,
Where is your further representation? 41.
sir, no, my lord.
Page 41 is your representation?
41, my lord. Yes, my lord.
So what are you asking for? For
My lord.
dismissal of this representation?
Yes, my lord.
Yes.
But
My lord, the petitioner is to ascertain under which jurisdiction this plot of land is, because the PWD
yes,
assistant engineer,
my lord, respondent 4, my lord.
my lord,
Kindly,
page 4, para 2,
Where is the reply to the earlier representation?
earlier
page 4, para 2, second paragraph.
my lord, that was orally stated, my lord.
Orally stated.
Yes, my lord.
Page 4, paragraph.
Paragraph 2, second portion. The respondent number 5 and 6 of the said petition orally intimated your petitioner the road over does not fall within their jurisdiction, and as such solemn order cannot be complied with, and supplied the particulars of the respondents under whose jurisdiction the road falls.
So now the petitioner says
My
that
lord,
it comes
respondent,
under the jurisdiction of respondent number 5.
yes, my lord, respondent number 4.
Yes.
Respondent number 5, my lord.
5.
Yes, my lord.
Hooghly subdivision.
Yes, ma'am.
So earlier it was under which subdivision? Who was respondent number 5 in the earlier writ petition?
Yes.
I hope it's not the same authority.
No.
No? You've checked? You've
Yes,
found out?
Malad.
So let it be sent to the respondent number 5 here. Yes.
Malad, one thing more, Malad, there is a typographical error. So far, respondent number 4 is correct.
Yes.
Instead of Arambagh, it should be Chingsura.
It should be Chinsura.
Chingsura.
Very good.
For the Chingsura.
And this is unauthorized occupation on PWD land.
Malad.
The petitioner has alleged. The petitioner has alleged unauthorized construction by the private respondents by encroaching upon PWD land adjoining his property, thereby obstructing his egress and ingress. Pursuant to an earlier order of this court, dated 2nd September 2021, in WPA 11825 of 2021, directing the concerned authority to consider the representation submitted by the petitioner in this regard, The petitioner was verbally informed that the said authority, that the land in dispute was not under jurisdiction of the said authority. The petitioner has filed a fresh representation in this regard before the and prays for a direction of regard on 19th July 2023 and prays for a direction upon the authority to consider the representation at the earliest. Paragraph: Learned Counsel for the respondent submits that the fifth respondent be directed to consider the representation in accordance with law as an engineer. Paragraph: in view of the above, the petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of, which at the first on prayer of the petitioner, liberty is granted to correct the designation of respondent number 4 in the cause title of the writ petition. Yes, next one. Item number 8.
Item 8, I have a petition, Your Lordship. The National Highway is a party to this matter, Your Lordship. I just received a call from Monica that to do some personal review, she is not able to come.
Lordship, I am praying for not today. On the earlier date also it was a not today, isn't it? This matter?
No.
Some other
This
matter.
is the first, it's coming for the first.
Several matters were made not.
Today it's fixed at 12:30.
Where? Oh, they are all mentioned matters.
Yes, they're mentioned.
On prayer of the, shall I make it not today only?
It's not today only.
Not today.
আজকে আমাকে আজকের জন্যই বলেছে 8, 9 same, Your Lordship.
8, 9.
11, 12 and 13.
So 9 also the national highways.
National Highway.
I am not 9. I am 8 and 12.
না 10 না আমাদের 10 বার
8 and 12.
8, 9,
11, 12 and 13.
11, 12, 13, same order.
Same. 10 and
Not today, have we got. 8, 9, 11, 12, 13. 10. No, not today, not today.
Yes, my lord. My lord, I am praying for not today due to service is incompleted.
Service incomplete.
Yes, my lord.
Since service is not complete, comma, let the matter stand over till
Ma'am, kindly it to be fixed on
9th May.
9th May. Grateful,
File
ma'am.
an affidavit of service on the next date, right?
Okay.
Next.
নামটা কি লিখে দেব
হ্যাঁ দিচ্ছি
সব কাগজে একটা কাগজ দাও
Item number 14. Yes, 14. None appears. The matter is adjourned for the day. Next. Item number 15.
আপনার নাম দিয়েছেন
15, anyone? None appears. The matter is adjourned for the day. Next. Item number 16. Same order. Item number 17. Same order. Item number 18. Same order. Item number 19. None appears for the petitioner. The matter is adjourned for the day.
Item number 20.
And appears matter is urgent for the day.
Item number 21.
My lord, I am for the petitioner.
Response.
My lord, the petitioner is the
I cannot take up the matter in absence of the, have you served the private respondents also?
my lord,
So shall I make it not today only?
my lord.
Give this to me on Monday. If I'm not passing an order, just not today.
My lord.
Not today. ওটা ফেরত দিয়ে দিন উনি সোমবারে দেবেন।
Passover, my lord, on behalf of
Passover is not possible. I'm making it not today.
Not today.
item 21.
এই তো আমি তো আছি।
ও, তুমি আছো?
ওরাই চাইতেছ।
Item number 22.
Yes, my lord, I appear on behalf of the private respondent number.
Petitioner, anyone for the
But I
petitioner?
am for the state.
Petitioner, no one. So not today. None appears for the petitioner. The matter is adjourned for the day. এটা order করুন।
I am ready.
Next.
Item number 23.
None appears. The matter is adjourned for the day. Next.
Item number 24.
None appears for the petitioner. The matter is adjourned for the day.
Item number 25.
None appears. Matter is adjourned.
25, I am for the petition.
Petitioner.
Petitioner.
Respondent.
No, I'm sorry, 26, 27, not 25, I am for the respondent.
In this matter,
Right.
yes, in this matter,
Take up the matter.
Today, they withdraw the petition.
my lord, my instruction is not to proceed with this matter further, but I have to take the instruction in writing. Therefore, your lordship kindly takes up after 7 days or 10 days. I will file the in written instruction.
ওরা withdraw করবে আর কি।
I'll record your submission and
No, lordship, kindly allow me to get the instruction in writing.
on prayer of the petitioner, the matter is adjourned. Paragraph next week,
Lordship, kindly keeps it next Friday.
Thursday, 18th. Let the matter appear under the same
It
heading
my matter
on
to
18th April. So we can dispose it.
Yes, yes. Grateful to your lordship.
Next.
কেন?
একটা demolition public land.
Item number 26.
Well, 26 and 27 both are analogous. Two different reasons. Cause of actions are different, but in respect of the same property. What has happened? The authority has issued a notice under section Public Unauthorized Occupants Act. Thereafter, they tried to proceed in that proceedings. Then they got stuck because I came before this court and obtained an interim order. Then this honorable court has asked me, you challenge that particular order before the appellate authority. I have filed section 5 application along with appeal, they have rejected my Section 5 application. Challenging that Section 5 application, that order, I came before this court,
The
Honorable
second
Court, second round of litigation. Then again, my lord, this Honorable Court has allowed my Section 5 and directed the authority to hear out the appeal. Appellate authority has, my lord, after the allowing Section 5, since the Honorable Court has allowed Section 5,
My lord, in this matter,
then
28 and 29, two matters is there, my lord.
26 and 27. 26, 27.
I do not find the respondents to.
Kindly fix a date, my lord. Why, my lord?
For the day.
Yes.
None appears for the respondents. The matter is adjourned for the day.
তাহলে সেটা থাকবে, হ্যাঁ। তাহলে it will retain its position.
Next. It's 28.
20 and 29.
Lord, I am for the respondents WVACT.
Petitioner,
But I do not know petition.
no one. None
For
appears for the petitioner. The matter is adjourned for the day. Next.
28 and 29.
They're analogs. They're analogs.
Analogs.
Item number 30.
আমার নামটা শুনুন।
30 my lord, I am for the petitioner, my lord.
Respondents. For the respondents, the matter is adjourned for the day.
Thank you, lords.
Next.
Item number 31.
None appears. The matter is adjourned for the day.
Item number 32.
My lord, I am for the municipality, my lord.
32, I beg to appear for the petitioner. my lord.
Who is appearing for the state?
I am for the municipality, my lord.
State.
Grievance allegation against the municipality.
But today I cannot pass an order.
My lord, that is.
On none appears for the state respondents. The matter is adjourned for the day.
My lord, one submission, my lord. Last occasion, your lordship
Oh,
had.
Mr. Banerjee is here.
No.
The municipality was directed to file a report regarding the acquisition or whatever right they have
That
over
is
the
on
report.
record.
That
Report has been filed.
What would be accepted to you?
अच्छा, हमने इतनी नहीं.
My lord, report, just, it would be apparent, your lordship, if I just place
Come
to,
with an exception. Do you want to file an exception?
well, exception is not required because in the report, the stand of municipality is not clear. There are 2 points which has been highlighted in the report. One, it says that there was no interim order. I have documents to show that there was an interim order. At one point of time, interim order was vacated. Thereafter, it was restored. Secondly, it is not clear what is the stand of municipality, whether they intend to, if I, lordship, may I just place the report, 3-4 lines report. Paragraph number 5 is the, my lord, the only paragraph from which it is not clear whether the municipality have any intention to make any construction. This is reiteration of the statements which are made in the petition itself. Your lordship, may I just place it?
Yes.
Paragraph 5, I state that the petitioner stated in paragraph 6 that on 21st December 2021, petitioner received a notice by the administrator of Tarokeshwar municipality and directed upon the petitioner to be present on 23rd December 2021 at 11:30 a.m. with regards to construction of a road from TC Road to New Bus Stand. And paragraph 7 of the petition, petitioner stated that his son as a representative to be present, and petitioner stated that the authorities of Tarokeshwar municipality intends to construct a road from TC Road to New Bus Stand over the petitioner's plot of land. Municipality has not construct a road over the petitioner's plot of land. On 13th January 2022, the Office of the Board of Administrator issued a notice upon the petitioner to hear the matter in connection with to construct a road from TC Road to New Bus Stand. On that day, son of the petitioner appeared before the Board of Administration and submitted an application before the board for taking some time for hearing and requested to fix another date for further hearing. The petitioner stated in paragraph 4 of the writ application and annexing the same at page 14, annexure P1, that Executive Officer Tarokeshwar Municipality issued a letter to Sri Chittoranjan Chel and others regarding according to land with reference to your letter asking for information regarding itself. My lord, what is the stand? My allegations is that they at certain point of time, certain heavy equipments were put into my property and my lord, there was an intention to make certain constructions. That is our case. Prior to purchase of the property, we obtained an information from Right to Information, which shows that this property was never acquired.
Status. What is the present
My lord,
status
the
of
land is there, my lord.
No construction has been
Now, after filing of the writ petition, the heavy instruments were removed. Your lordship kindly sees my writ petition. The photographs were annexed, which shows that there were some constructions. Now, I was informed these constructions were stopped at page 28.
So your purpose is served.
My lord, if municipality intends to my lord, make any construction, there are certain provisions which my lord, we entitle my client to get compensation. We are not that. Whether they have to file a report, whether my allegations were correct, whether there is any intention to, if they don't want to construct, my lord, your lordship can record it and my lord pass necessary orders.
So you do not want to, you intend to construct.
No, my lord. What a petition, municipality has not taken any steps to construct the road of the petitioners, my lord.
But intend to do so.
Yes, my lord.
They
No.
said that they will not make the construction over the land of the
Petitioner.
petitioners. So dispute boils down whether the road which is being constructed touches the petitioner's land or not. The disputed question of fact. He says they are making, but municipality is saying that they are not making over your land.
Were there.
But municipality
And they called us.
Land.
They called us.
Yes,
Your lordship kindly sees the notice. They called us, my lord, at page number 26.
Yes.
But my apprehension was, and that has been, my lord, fortified by this notice. উপরোক্ত বিষয় টিসি রোড থেকে নতুন বাস স্ট্যান্ড পর্যন্ত সংযোগকারী রাস্তা নির্মাণ সংক্রান্ত। It is addressed to me, your lordship kindly sees. Srimati Chandrakala Devi Agarwal, serial number 4, Prapok.
It's also not very clear as to
My lord,
whether
that
your
is the
land is
thing.
required.
My lord, that is the thing.
If your land is
But this
required,
letter
then
was,
steps in accordance with law.
my lord, this notice was sent to me. We attended on the particular date. That date, nothing was done, my lord. No hearing took
No, you
place.
have taken an adjournment on
My lord, that is another date, my lord. Your lordship sees. Whatsoever, my lord, we have been called.
From the municipality that they are not going to construct over their land. Now,
Let me record that.
And
Yes,
my lord, pass necessary
Yes.
orders, your lordship.
Heard learned counsels for the parties.
দাদা আমরা একটা কপি
Tara, the petitioner does not intend to
অনেককেই
use
ডেকেছিল।
an exception to the report in the form of affidavit submitted on behalf of the municipality. Capital heard learned counsels for the parties. The
জায়গাও মালিকই না
grievance of the petitioner is that the Tarokeshwar municipality, being the third and fourth respondents herein, are trying to construct a road from PC Road to New Bus Stand by encroaching upon a portion of the petitioner's property. Record reveals that a notice in this regard was issued upon the petitioner, a notice of hearing in this regard was issued upon the petitioner by the authority on 21st December 2021. Paragraph. Learned counsel for the municipality, submits, on instructions, that the municipality does not intend to make any construction upon the petitioner's land or any portion thereof. Paragraph in view of the above, comma, nothing further remains to be adjudicated in the petition and the same is accordingly disposed of. Paragraph, however, comma, if the municipality requires the land of the petitioner for construction in future, comma, they shall be at liberty to acquire the same by taking recourse to law. Disposed of which?
Grateful, Lord.
Grateful Lordship.
Next. Item number 33.
For the petitioner, madam.
I am for the respondent number 5, my
Good one. Actor line add করুন যে learned counsel for the petitioner's land by the municipality to law. Yes.
I'm for the petitioner, my lord. On the last occasion, my lord,
You are appearing for?
respondent number 5, my
on the last occasion, your lordship please to direct the Rehabilitation Advisory Committee to file a report in the form of affidavit.
Who is appearing for the fourth respondent? Rehabilitation Advisory Committee?
Separate advocate is there. Separate advocate is there. Advisory committee. Yeah, paper is
Here, Mr. Maiti's record name is recorded.
No, I am for the respondent number 5, hold the development,
Wrongly recorded as 4.
hold the development authority.
Mr. Uchait was appearing.
The chairman is the DM, my lord.
You can present.
My lord, some more time is required for.
A report was called for.
Yes, yes.
Please see the order passed on March 7.
Yes, my lord. I have a note. There's the dates.
Petitioner applied for allotment of rehabilitation plot.
Yes.
You have disposed of that application, but that order is not there. You are supposed to annex that order to your report.
Next date was. But I'm paying.
Kind.
Yes, ma'am. For
Let
date.
him come back with the report. Learned counsel for the state respondents. Item number 34. No one, none appears. The matter is adjourned for the day. Item number 35.
35, my lord, I am for the petitioner.
Respondents,
I am for the respondent number
respondent number
4, my lord.
Development Authority.
My lord,
Hold the development.
hold the development. Chief Executive Officer, hold the development authority.
No one for the state. Let it be adjourned for the day. None appears for the state respondents. The matter is adjourned for the day.
Affidavit of service be kept with the record.
শুরুতে affidavit of service. Next. $36. কি হলো?
Six or eight.
Not today.
36 not to go to the. 36 not today.
37.
Item number 37.
My lord, in this matter, Mr. Jawaharlal Rai appearing on behalf of the petitioner, he is not come to the court. I am praying only not today, man, due to his illness.
Not today.
Great.
Next.
Item number 38.
38, my lord, I am for the private respondents. Respondent number 6 and 7.
None appears for the petitioner. The matter is adjourned for the day.
Item number 39.
My application for being added as a party matter, there was a direction for affidavits. They have not filed. The petitioner has not.
No one. Let it be adjourned for the day.
Madam.
None appears. Let it be adjourned for the day. The matter be adjourned.
Item number 40.
I appear for respondent Hitco.
None appears for the petitioner. The matter is adjourned for the day. Forty-one.
41, your lordship, and for the petitioner, your lordship, I'm praying for
Everyone.
Item number 41.
I appear for respondent number 4, my lord.
41, your lordship, I'm praying for not today, your lordship. I'm praying for not today on behalf of Mr. Smayashistian.
State, Mr. Bandopadhyay is there. Then it will not be not today. Everyone is there. Make your submission.
Lordship, actually,
Last occasion, it was for the adjourned, my lord, I submitted before your lordship, my lord. They have prayed for the demarcation. Demarcation or.
Interest.
Sorry,
not, lordship, kindly makes it not today, your lordship.
Yes.
Not today, your lordship.
On prayer of the petitioner, the matter is adjourned. Everyone else is there.
Lordship, kindly makes it not.
Respondent number 4.
19th.
19.
Let the matter appear under the same heading on 19th April. Forty-two. Oh, no one. None appears. The matter is adjourned for the day.
Next হচ্ছে না আরো। Next হচ্ছে। Item number 43.
None appears, the matter is adjourned for the day.
Item number 44.
My lord, Mr. Devajyoti Vasu is appearing in this matter. My lord, I am praying for only not today.
My lord, I am appearing for private respondent number 4 to 6.
State. None appears for the state respondents, the matter is adjourned for the day.
Forty-five, my lord.
45 is at 11:30, so.
11:30.
46.
46, my lord, I am for the petitioner. My lord, the difficulty is that it's a group 7 matter, my lord. My lord, it was 6. It was, my lord, restored. After that, my lord, came into the heading of group 1.
My lord, kindly see the order dated 25th July, my lord. It has been already been dismissed, my lord.
Dismissed key for
Withdrawn, no. Withdrawn with liberty to fresh application. Kindly see order dated.
Dismiss for default, then.
Yes, my lord.
For default, then restored.
Was restored.
My lord, thereafter 25th July, one order has been passed that they have paid for withdrawal the petition with prior to file fresh application. My lord, kindly see 25th July.
Yes, they sought liberty to withdraw the application, not the writ petition.
My lord.
They withdrew the application, not the writ petition.
My lord.
CAN 1 of 2023. See the order.
My lord.
This is a group 7.
Group 7 matter, my lord. Kindly sees the prayer, my lord.
Motion.
Motion stage, my lord. Motion stage. It was, my lord, running in the group 7 list, my lord, for restoration. After that, my lord, came to.
Let the matter appear under the heading group 7 motion on 10th May.
Grateful.
Grateful.
Next.
In May.
Item number 47.
Here for respondent number 5.
None appears for the petitioner, the matter is adjourned for the day.
Item number 48.
Petitioner. None appears for the petitioner, the matter is adjourned for the day. Oh, yes, let's. Rajiv, report submitted. The form of affidavit submitted on behalf of the state respondents. Next.
They were waiting, just call them.
Item number 49.
Item number 49, my lord, I bring for the respondent KMC, my lord.
Petitioner.
Now, my lord, on the last occasion, your lordship was kind enough to direct, my lord, the corporation to, my lord, file reports in the form of affidavit. My lord, I have served a copy. Yes. I have served a copy, my lord, prior to the matter being taken up. And for the corporation, my lord, this is my affidavit, report in the form of affidavit.
Served?
Yes, I have served it.
Yes, my lord, I have got them. No, my lord.
Exception needed.
My lord, perhaps no.
But the hearing,
Why, my lord,
I am told, is still continuing. Probably, well, subject to what my learned friend says. That is the instruction that I have got last occasion.
For mutation, 3 dates. My writ petition, my lord, kindly come to my lord's original order, my lord, that is at.
Kolani or Salt Lake?
No. this is a property situated in KMC area where on my property they have put up a light post and complaining of that particular thing. I have come before this court, and previously in a previous litigation there was a direction by this honorable court, my lord's court, to consider my mutation application, that is of 2007. Now, my lord, kindly come to my lord's 22nd August 2023's order, where my lord has specified the facts, my lord, in gist. My lord, in an earlier writ petition being number 2007 filed by the predecessor in interest of the petitioners, a coordinate bench of this court by an order passed on 3rd June 2013 directed the municipal authorities to accept the mutation application to be filed by the petitioners therein and consider and dispose of the same within a stipulated time frame. The contention of the municipal authorities in the earlier writ petition was that the property of the petitioners was not numbered and also not assessed. Since the municipality did not have unassessed and unnumbered property in the area, no action could be taken by the municipal authorities. The said contention is reiterated by the learned counsel for the KMC in the present writ petition also. Then, my lord, the petitioners allege that the KMC has put up a signboard in their property without any authority to do so. Let a report in the form of affidavit be called for from the KMC demonstrating whether the application for mutation submitted on behalf of the predecessor in interest of the petitioners has been considered by the authority in compliance with the order of this court, and also under what authority the signboard has been put up by the KMC in the plot in question. Now, my lord, this report only deals with that my mutation application has been my lord, entertained, and they have issued several notices for hearing. Various dates have been fixed. Nothing, no whisper about the signboard and what was the authority the municipality has put up.
I'm coming to that. There are two issues, my lord. One is regard to the mutation, my lord. We are complaining this honorable court's order. But order was passed. Thereafter, your lordship directed us to comply.
Now
yes, now we are now my lord, we are. Let me say now. Now, my lord, we are complying with the honorable court's order. Lordship kindly takes up my report in the form of affidavit. Lordship kindly takes up page 12. Lordship kindly takes up page 12. A lot of things have been said, but the report has, my lord, the report, he says he does not need to take any exception. That means he is okay with the report. Now, my lord, will kindly allow me to place the report. Lordship kindly takes up page 12. This was, my lord, hearing held on, my lord, 5th December 2023. My lord, the parties are present, my lord, they have put in their signatures there, page 12. Now, my lord,
5th October.
Yes, 5th October 2023. I said 5th October. If I said 5th September, I was wrong. Now, my lord, matter discussed, but it is found that the owners have appeared, rather, Sri Rajesh Rai, advocate, come with one registered general power of attorney dated 23rd December 2020 and 8th January 2021, claiming that he is representing both the applicants. After prolonged discussion, it was advised to them to come up with due authorization along with all documents as discussed, also with the declaration that the said power of attorney still is enforced by the applicants. The next date for application appearance is fixed on 29 November 2023. Now, my lord, lordship kindly takes up page 13, 29 November 2023. With reference to our earlier order dated 5th October 2023, Mr. Pradeep Shet, power of attorney holder on behalf of the applicants, Sri Jahangir Das and Sri Brahmachari Nirmal Chaitanya appeared in the hearing and submitted the following. Power of attorney, of Jahangir Das, power of attorney of Brahmachari, then deed Madhusudan Go, Porcha Madhusudan Go. With reference to our earlier order of hearing where it was advised to come up with the authorization along with documents, it is found that only one authorization letter on behalf of the applicants separate has been submitted, but no self-attested copy of the applicant along with attestation of the documents as well as signature of the person claiming as power of attorney is found available. However, we checked the signature of the applicants from the copy of the documents attached with the power of attorney, and prima facie it was felt that the signature of the applicants available there is somehow not matching properly with the signature given in the authorization letter dated 21st November 2023. Since the matter is being under process on the direction of the Honorable Court as well as the quantum of land to be assessed mutated in around 20 kata, hence Assessor Collector is of the opinion that the personal appearance of the applicants along with proper ID will be prudent to deal with the matter without any difficulty, and the same was conveyed to Mr. Pradeep Shet appeared today on behalf of the applicants. The next date of hearing in this regard in presence of the applicants is scheduled on 15 December 2023. Now, my lord, this affidavit was affirmed on, my lord, 13th December. Now, my lord, prior to 15th December. Now, my lord, I have received, my lord, the copy of the hearing minutes. Let me say, you have said, my lord. Oh, very good. May I place, my lord, 15th? My lord, the 15th hearing was held as per schedule date, that is 15th December 2023 at 12:31 of the applicant, Sri Tutu Das, alias so and Sri Pradeep Seth, power of attorney and authorized representative of the Jahangir Das, appeared in the hearing. Referred the order earlier hearing dated 29 November 2023. It was found that documents like deed and porcha were submitted by them at our office. When they were asked about LR mutation certificate, they informed that the said mutation exists in the name of their grandfather Sri Madhusudan Guho, and they also acknowledge that it has not been yet transferred in their name. We cross-checked the same with Banglar Bhumi portal record and found it as correct. However, it was informed to them that the LR mutation is required in the name of applicants, since porcha is also in the name of Sri Madhusudan Guho. In compliance with the requirements as laid in the Citizens Charter 2021 of the Assessment Collection Department in connection with the assessment of unassessed land, they were requested to proceed for LR mutation in their name from the appropriate authority in this regard. Moreover, to reduce further delay, it is also decided that one physical inspection will be conducted on 27 January 2024 in order to identify the land for which application has been made. It was also requested to make Sri Jahangir Das, one of the applicant, to be present in person on the day of inspection as scheduled above. This was on 15th December. After this, Lordship, 29 January was, my lord, the date fixed. No, not on 29, probably 27. Yes, 27 January. Lordship has got the copy of 27. Yes, 27. No. May I just place 27? Yes, 27 was also held. Oh, my lord, on 27, yes, because they did not appear. My lord, I have the copy. Applicants did not turn up at the scheduled time. However, we waited for them till 12:45 p.m. However, one call came forward one call came to Ward Deputy Assessor Collector from the number 98300, etc. in the name of Mr. Pradeep Seth, authorized person as well as power of attorney for the applicants, and he informed that he is very much ill, and as a result, no one from their side is able to attend the hearing and physical inspection today, and they will inform the same in writing shortly. Hence, the inspection is adjourned. The inspection date we had fixed. They said that we are not in a position to be present at the time of inspection, so kindly adjourn it. Hence, the inspection is adjourned today, and the next course of action will be taken once the applicants appear in our office. This was on 27th January. Now, the next, my lord, I have received to the assessor collector by Pradeep Seth. He has written on my 29 January 2024. Respected sir, I see Pradeep Seth, authorized power of attorney holder.
Some record.
I'll put them. Yes, this document, no, I had affirmed the earlier affidavit by 13th December because Lordship's specific direction was to file that within a span of time. We did that. Now, this subsequent. Yes.
The signboard matter.
May I just place Mr. Pradeep Seth's letter before Lordship? I see Pradeep Seth, the authorized power of attorney holder for Sri Jahangir Das. Yes, inspection and mutation. May I just place this letter? Then I'll make my submission. Jahangir Das and Brahmachari, the petitioners before Lordship of the property measuring so and so, do hereby declare that I was to attend hearing schedule 27 January. Then my lord, he says, due to physical indisposition, I am unable to attend the hearing scheduled on 27 January. That I be granted another date. So, on behalf of the petitioner, a date was a time was adjourned and a further date was fixed. Today, I do not have that much instruction with me. So, what I humbly beseech your lordship is, lordship kindly grants me another 2 weeks time, so that with this subsequent development and what it stands today, I can put it in the form of affidavit and file it before lordship.
Subsequent developments are meaningless, according to me.
Yes, my lord.
For mutation, one doesn't need to go and inspect the property.
No, the property has to be identified.
After he finishes,
my lord, the property has to be identified. One has the physical identification. My lord, these hearings were made in their presence. The
authority goes to the local and they.
But if the physical, not only that. If the physical,
this High Court with the help of a power of attorney. Kindly take my petition.
Very good.
But I see the my lord, atrocious act of the authority.
No, we are authority.
Just to delay.
No, why? There is no reason why should delay. With everything has to be record. Because if we do not check the records and we mutate their name, then if tomorrow somebody else comes up, then my authority will be in difficulty. Very good. Let me take instruction because my learned friend also cannot apprise your lordship. What is the position today? But this was on
necessary at all. Number one, you have to mute it on the basis of the records. Please do this on the next occasion. To
yes, I'll lordship kindly grants me another 2 weeks time so that these developments and
you have not made a whisper with regard to that signboard.
my signboard. Yes, I have. Lordship kindly takes up the other affidavit.
Other affidavit.
Yes, there were 2 affidavits.
সেটা আমরা জানবো কোথায়?
তোমায় দুটো দিয়েছি তো।
আমায় একটা এভিডেভিট।
দেখো একবার। এই তো। But two separate affidavits were to be filed because there are 2 departments concerned. That is why, my lord, we have to take out 2 different affidavits.
You say that no signboard has been erected.
No, normally these things are done. Lordship will kindly
appoint a special officer.
These things are done by the Parks and Squares department. Now, this is an affidavit affirmed by the Parks and Square department. They said that they have not done. Lordship kindly takes up paragraph 4 itself of the affidavit. And 5, they have not erected anything. This is the instruction that I got from the Parks and Square, and this has been put on affidavit. So, my lord, these are the 2 affidavits that I have filed in compliance with the lordship's order. Now, my lord will kindly allow me to, in 2 weeks' time, I can put affidavit with regard.
Thrown out. It is not your signboard. You have
naturally the consequence will follow. My lord, with regard to what is happening in the mutation, lordship grants me another 2 weeks' time. I'll file everything that has happened after my filing of the earlier affidavit. That much I can pray before your lordship. No, we have to
I have got the
check up that.
I have got everything.
Today, my learned friend is raising his voice. আমি তো কিছুই বলছি না। But raising one's voice does not, my lord, allow him to, but the authorized person who are appearing there, they are not able to produce the documents. They are paying for time.
দেখাচ্ছি।
Lordship kindly allows me, my lord, 2 weeks time.
Documents. You are not able to. You are not inclined to mutate.
No, we have no reason. We have no reason to disallow their mutation. There is no reason. If they can produce.
There may be extraneous reasons.
Yes.
Valid reasons.
May I just come back after 2 weeks with another affidavit?
Let him come back. I'll pass an order on the next date.
Yes. Grateful to your lordship.
And just uproot the signboard and throw it off because it's not theirs.
My lord, kindly.
Come back. I'll
yes, lordship will allow me only to file an affidavit. I'll within 2 weeks, my lord.
How they are harassing.
Slip din na.
My writ petition is getting entertained on the basis of power of attorney, but they are not.
5 and 6.
At a slip din na.
Are taken on record. Paragraph learned counsel corresponding numbers 5 and 6 seeks to use a supplementary in this regard. Paragraph let the matter appear under the same heading on 15th May. Please serve an advance copy. May.
Yes. I'll just have an advance copy.
That proceeding to be over by then.
Yes. I'll talk to them.
Note.
8. Grateful to your lordship. Lordship kindly record that I filed the affidavits. Lordship, I record deeply obliged.
My lord, matter fixed at 11th.
Yes.
Deeply obliged.
My lord, senior is here. My lord,
My lord,
কি হলো
একটু স্যার
আবার কি হলো স্যার অসুস্থ হয়ে গেছে
He's not well, I believe. He's not well. So you want it on 9th and 10th?
I hope, my lord, this matter is not making him ill because frequently he is falling ill. When is
he's asking for 9th and 10th May if it is all right for you.
9th and 10th?
9th is probably a holiday, Lordship, if not wrong.
8th is a
8th is holiday.
Ravindra Jayanti is 8th this year, not 9th.
8th May is a holiday.
Milord, I am appearing for respondent numbers 8 to 13. I'm led by Mr. Mitra in this matter.
Yes.
I'm appearing for 8 to 13, Milord. I'm led by Mr. Mitra in the matter. Unfortunately, today I could not come.
Yes, your senior friend is here.
কি বলছেন?
I had a
yes.
personal difficulty today, my lord. That's why I could not be present.
That's fine, but I would like to ask Mr. Yes, so you're coming from Delhi, so is it all right for you? 9th and 10th?
9th and 10th, my lord. I think it's all right, my lord.
I think it will be all right for him.
Will it be all right for you? So shall I
Yes,
fix
ma'am.
9th and 10th?
Yes, yes.
11:30?
11:30.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 9th May bracket 11:30 AM and 10th May bracket 11:30.
Well, kindly also have it recorded that at the instance of my lord, my learned friend's client, my lord, the matter is being adjourned.
Yes, yes.
Yes.
Thank you. On prayer of the petitioner, yes.
At 11:30, my lord.
11:30, 9th and 10th.
Okay.
My lord, I tend to agree with my learned senior, my lord. Probably this matter is making him sick.
কি হলো কি তোমার? তোমার কি হলো?
I'm obliged. Great. Great.
Next.
Obliged.
My lord, 50, 51, 52, similar matter is fixed 15 May. Already fixed.
Already fixed.
50, 51 on 52, similar matter.
Oh, similar matter is fixed on 15th May.
Yes, my lord.
I'm appearing on behalf of Bardhaman Development.
On prayer of the petitioner, the matter is adjourned.
51, 52.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th May. 15th May. 50, 51 and 52.
50, 51, 52.
50, 51, 52, 15th May on prayer of the petitioner.
On, my lord.
15 May.
15 May.
Next.
Oh, ask them.
51, 52, same order. Item number 53. Anyone in 53? None appears for the petitioner. The matter is adjourned for the day. Item number 54.
Also, I'm for the petition.
Respondents. None appears for the respondents. The matter is adjourned for the day. Item number 55.
I am for the respondent. Which go 2 and 3.
Petitioner is not there today. None appears for the petitioner. The matter is adjourned for the day. I think
Our names may kindly be recorded. Hello? Our names may kindly be recorded.
For the petitioner. I am praying for not today.
You're ready? Ready?
I am praying for not today, my lord. Mr. Tulsidas is appearing for the
You're the
petitioner.
advocate?
No. No, man.
Are you appearing in this matter? No.
No, Mr. Tulsidas Ra is appearing this matter. Kindly.
Adjourned for the day.
45, 55.
Item number
Yes, ma'am.
56. None appears. The matter is adjourned for the day. 60 of the document. No use calling matters like this.
60. Your officer is called 60.
No, no.
I'll call 60. Item number 57.
57, my lord. I am for the petitioner, my lord.
No respondents. Anyone? None appears for the respondents. The matter is adjourned for the day.
Kindly record my presence, my lord.
Give your name, it will be recorded.
Yes, yes. Petition.
No, straight. I'm the officer director.
সেখানে এনেছেন এখানে দেবেন তো আজকে বলেছিল
Fine.
যাবে
I've called till 60. No use calling matters like this. They'll type same orders.
Spite of that, my lord, that is in every case, my lord, that one.
Item number 58.
Hmm? 58, anyone?
Idiot, I'm for the petitioner.
I am for the state, my lord.
Union of India?
Yes, I'm appearing on behalf of the Union of India.
So we are ready for hearing in this matter. Yes.
Lordship, Mr. Brojesh Shah appearing in this matter on behalf of Union of India. Lordship, I'm praying for not today. He's
All matters cannot be made not to. On prayer of the Union of India, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th May.
Lordship. Oblige, Lordship.
Union of Indian appearance.
ইটকো আছে এর মধ্যে
No petitioner.
ঠিক আছে নামটা দিয়ে দেয়
Nine rules for the petitioner.
59 or 60?
60. Praying not to the Lordship.
the state respondents.
I have it for the non-answering respondent.
Item number 60.
Petitioners.
I'm for the state, my lord.
State. You're the petitioner in both the matters.
Yes, 59 and 60.
11. Let it be adjourned. On prayer of the petitioner, the matter I'll not make it not today, I'll give a date. So many matters cannot be made not.
Only not today, or your lordship is fixing the matter.
I'm fixing the matter. On prayer of the petitioners, the matters are adjourned. Let the matters appear under the same heading on 10th May.
Surprisingly, the petitioners are the most absentees,
Yes, yes.
which is the other,
Recorded petitioners.
should have been the other way around.
No, no, several matters the petitioners are not there.
আরেকটা কথা আছে
It's nice to have a holiday in between, isn't it? I think I choose to rise. I'll come back at 12:30 for the mentioned matters. No use calling matters. There's
yes lord I have 63 your lordship will not be taking
I will not call the matters. I'll come back at 12:30 to call the mentioned matters.
lordship lord
I mean,
I'll 63 hours
Yes, there's a 12:30 fixed line.
Yes, well, I believe my learned friend wants to say something.
If you, yes, I may be permitted to take.
Yes.
My lord.
You're
Last
appearing,
occasion, I have elaborately discussed.
you're appearing in this matter.
I'm appearing for the respondent number
754.
750. 750.
Yes.
The last occasion I have elaborately discussed.
Yes.
Various
Yes.
issues. Now, I want to point out some undisputed points. That is, these expired.
Just a minute. Who's appearing for the Union of India?
Appearing on behalf of the Union of India, my lord.
Yes. Who's appearing? Oh, right.
I have already made my submission on the last occasion,
Yes.
My lord, undisputed that is, lease expired on 29 March
Yes.
2021.
Yes.
This is the undisputed. And thereafter, this has not been extended. This is also undisputed.
Yes.
Now,
you've stated this earlier.
And after series of making correspondence with regard to further renewal, finally we have served notice on 29 March 2023. First notice. Though the lease expired long ago, in the year 2001 itself. 2021. My lord, on the part of the airport, this is a case of unauthorized occupation by the petitioner in respect of the airport premises in view of Airports Authority Act 1994. Only I am reproducing the particular section. My case type of falls under Airports Authority of India for adjudication. My lord, chapter 5A, chapter 5A,
yes,
section 28A. No, it I have not put this particular section. A. I have not. Right. I have not shown the provision from the book. My lord, as per section 2A, 28A, unauthorized occupation in relation to any airport premises is the occupation by any person of the airport premises without authority for such occupation and includes the continuance in occupation by any person of the airport premises after the authority within bracket, whether by way of grant or any other mode of transfer under which he was allowed to occupy the premises has expired or has been determined any reasons whatsoever. In this case, it has not been determined. On excludence of time, this expired. And as per this definition, continuation thereafter, it will be unauthorized. So my case, they are unauthorized occupation. We have not yet started eviction proceedings under the Act because we have 2 years time we have given. So my lord, it is a settled law that under lease agreement, when a registered lease deed is executed after expiry of the period, unless it is extended, no notice is required.
Have you started eviction proceedings?
My lord?
Have you started eviction proceedings?
No, no.
In accordance with law?
31st March, our period, we have given the time to vacate.
Yes.
So long ago it was expired, 2 years ago. Since it is the educational institution, we have given sufficient time to take alternative arrangement, nearly 2 years, and they have not taken any step. Now, my lord, it is my statutory right to proceed under AI Act for their unauthorized occupation for their removal. We will not take law in our own hand. That proceeding is right arising out of this statute. So my humble submission, there is no prima facie case to get any stay order or injunction. Otherwise, matter will be dealt under the law. That is my.
That's all.
That's all.
Yes.
Let me I deal with the last point first. On the last occasion, Millard, I have, Millard, placed in details, Millard, the orders, Millard, which were passed by the Honorable Court of this Honorable Court, which has been accepted by both the parties, acted upon, and that or those orders, Millard, confer certain rights on me. I'll come to that later on. But first, Millard, the last point, which says that we have not extended or AAI has not extended my lease. When my respectful submission is made, all these pages I have shown, please note it, Millard, for the purpose of collation, Millard, on this point.
Yes, yes, yes.
Page numbers 159, 160, 164, 166, 169, 170, 173, 174, 177 and 184. Now, what are the purport of these pages, Millard? Number one is, Millard, when I apply for extension, they say that you apply in the prescribed format for the purpose of processing. I do that. Thereafter, Millard, they ask for this document, that document, I give them. Then they ask for, Millard, the financial documents, accounts, etc. I give them. Finally, where do we stand? Today, Millard, we stand at a situation where the extension will be granted at 1 rupee or 3 crores and not. That is where we are standing. Therefore, Millard, as a matter of policy, if I may use this expression, Millard, there is already a decision to, Millard, extend. My respectful submission was that when extension decision has been taken, otherwise, Millard, there was no reason to process it. Give me the prescribed format, ask for my documents, and they use the expression to process. That your Lordship will find me at from page 159. Yes. Therefore, my Lord, there is, my Lord, no dispute, no question raised in regard to, my Lord, extension. Whether, my Lord, it is at rupee 1 or 3 crores and odd is the subject matter. My Lord, I respectfully submit, my Lord, the orders of this Honorable Court, my Lord, has attained finality where, my Lord, I have a right to stay at rupee 1 so long the school runs. This is the expression used by the this Honorable Court in the previous round of litigation. It's nobody's case that school has stopped running. School is running, my Lord. Therefore, my Lord, I am protected by the orders of this Honorable Court. Now, my Lord, if your Lordship may kindly have a look to, my Lord, page 48. But important rights, my Lord, have vested in me.
Not on facts anymore.
No, just my Lord, 2 or 3 sentences as to what rights are vested in me.
Yes.
Well, my learned friend is speaking of, my Lord, me becoming an unauthorized occupant. That's why. "48, my Lord, the last 4 lines.
Yes.
We're in the middle of a sentence, my Lord, and to avoid any future difficulties in the administration and running of the school at the new site, the following order is made. The land so allotted shall vest in the airport but the school building constructed thereon shall belong to the school. Therefore, the building, my lord, today belongs to me. Where my learned friend is harping upon, my lord, I being an unauthorized occupant today. My lord, none of the statutes which describes unauthorized occupant, including the present statute over here, my lord, has taken note of a situation like this, where somewhat like the Ithaca tenancy, land belongs to someone and the structure belongs to someone. Therefore, my lord, important right has vested in me insofar as the building is concerned. And my lord, there cannot be any building without a land. I cannot keep the file unless there's a table.
Yes.
Then will please take the next line at page 49, the first line. So long the school shall be done, the school shall pay rent of ₹1. Therefore, my lord, they cannot ask for 3 crores and not today. Then, my lord, two other pages, page 53 and 57. Kindly see, my lord, page 53, second line, point number 3. After the second line, at the second line, keeping in view the requirement of IAAI of its future cargo activities, it was indicated that this plot would also not be available for the new building. But that was taken consideration of. Alternative sites, keeping in view, etc. Last is, page number 57. This is very important for me. Where fourth line, from the top, middle of a sentence. In the event the school building is taken over by the Public Premises So and So Act, the respondent shall provide alternative, equivalent, and convenient accommodation to the school near airport at the cost of the respondent. Everything is, decided. Where the Honorable Court was not oblivious that in future this land may be required.
This order was not carried in appeal.
No one. Well, these are my very respectful submission, and other things, at this stage, I will not, trouble your lordship with, I was praying, your lordship may extend the interim order, which has been passed. My learned friends may file their affidavit if they so desire, and kindly, hear out the matter, because today everything is finalized. But in the
Be disposed of upon such these submissions made by both the parties.
I think, this will be carried in appeal. Whoever succeeds, loses, they will let the pleadings be complete.
Yes, sir.
My lord, this alternative site for school, so long school run, was meant if the land is taken within the lease period. That is the
Where is that
purpose. Within
is
the
that
lease
recorded in
period.
the order?
Because
Is that recorded in the order? Please come to page 57. Please come to page 57. Is that recorded in the order? Is there any time frame stated?
Why this came? Because at that time they were asked to shift the building. That building was in other side. Only time being this arrangement was made to shift other side was given for 30 years only. So all this assurance regarding continuation of the land occupation will be valid for 30 years only.
And you still want to use affidavits, or shall I dispose of the matter on the submissions made by you?
Extent, but all the documents what have been disclosed, there is no other documents.
That's what I even feel.
Very well. If you kindly record that they don't want to.
Want to come use an affidavit, so that this point is not taken for the appellate.
Very well. Kindly record that.
So let's reserve this for judgment. I'll extend the interim order till delivery of judgment.
My lord.
Yes.
When the last order of the Honorable High Court under Article 226, it was never indicated that lease will go beyond 30 years. Whatever the conditions set out therein, that would be applicable during 30 years. If during 30 years we want to remove, then the question of giving alternative site will come.
First line take the
Where is that stated that it should be within 30 years? And once you cross 30 years, you can remove them. You can evict them. Where is the leverage for 30 years?
Either in the order of the Honorable Court or in the lease term, there is no such provision to go beyond 30 years.
Where is that stated, sir? From where do you get this 30 years?
My lord, case 126.
Yes, 126.
The leasing, if that clause is accepted, then the intention is very clear. The leasing shall be entitled to remove any materials, installations, equipment brought by the leasing in the demised premises within 30 days of the expiry of the lease, unless extended.
30 days. You're talking about 30 years.
30 days from the date of expiry.
Yes, absolutely.
The lease fails to remove, then other action will be taken to
Milord, I have placed this from the lease deed, the page from the lease deed itself.
these terms. Yeah, and subsequently, the matter of execution of lease was brought under the notice of the Honorable Court.
Milord, one line would have sufficed. We are not extending your lease.
That is their intention. They don't intend to extend.
Case 48, my lord. The physical copy of the order. Actually, this decision has been taken by the Civil Aviation Ministry to give the land for 30 years. It has been recorded. The new building would be constructed. Pursuant to the said decision, the authority has now allocated a piece of land measuring out about 4068 square meter on lease for 30 years on the basis of a token license fee. On the 30 years. So all the conditions, alternate site, anything that is applicable within that lease period. They have neither statutory right to occupy, nor agreement, contractual right, nor any legal right. Order is very clear, my lord.
Reserved.
I'm grateful.
The interim order will be extended till delivery of judgment. Heard learned counsels for the parties. I think arguments concluded, judgment reserved. Paragraph interim order granted earlier is extended till delivery of judgment. Further affidavits will not be required.
Wait, but kindly record
The
that.
documents, I'll
That
record.
that
I'll
they have foregone their right to file that.
All the documents are on record.
Very.
Yes, next. Madam.
I'm grateful.
Mr. Dotto, this may take some time because I'll be on the Jalpaiguri circuit bench in the meantime for 2 weeks.
Next 2 weeks.
Next.
Port Blair? No, Jalpaiguri.
For 22nd. So I'll be back by the first week of June. I may not be able to before that.
But 759 is the last 12:30 fixed matter where I need to assist your lordship. Can it be mirrored after your lordship returns in that case?
759.
759.
It was fixed at 12:30.
Yes, that's what I'm told by Mr. Dey.
You are not ready today.
No, I'm not ready.
I'll grant an adjournment then.
My lord, I have. No, Mr. Dey is with me. Mr. Dey is with me.
Oh, state.
That is the Obrotosh Mujumdar was there.
For the
Obrotosh Mujumdar.
Order was there.
today in any case, I cannot take it up but
Very.
in absence of the other side.
Very.
কেন আজকে কোনো resolution আছে? হ্যাঁ,
বইটা লাগবে আমার এখানে আমি
যাবে না তো।
এই বইটা এনে দিতে বলেছিলাম।
আমি বলে দেবো তাকে। পরে phone।
এটা নামটা লিখে দিন, এটা আমাকে আমি দিয়ে দিচ্ছি, জাজমেন্ট দিতে পারবো। কোথায়? কই?
Item number 727.
727 is petition for filing of reports, which shall be paid for extension of time.
Not there. Petitioner is not there. So I'll give a date and I'll not make it not.
Fellowship, can you fix a date?
Because you'll need some time, isn't it? You're for the middle development. None appeals for the petitioner. কত নম্বর রেসপন্ডেন্টটা দেখে নি। You are the sixth respondent?
Yes. And I have
Done it count. Your report is on record, I think. Mr. Day has filed your learned counsel for the sixth respondent seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 14th May. Next.
Item number 728.
But I'm for the petitioner. My lord, may I kindly see the last order,
Mr. Day is appearing.
13th March 2024.
দেখে না আমি যখন অর্ডারটা করে পাঠাবো ইন্টারমিডিয়েট দেখে না তারপর চেম্বারে পাঠাবো লয়ার ওই যে ভদ্রমহিলা যে রেসপন্ডেন্ট হয়ে বলছিল এয়ারপোর্ট অথরিটি হয়ে একজন ভদ্রলোক করেছিল তার সঙ্গে
অ্যাফিডেভিট সার্ভিসটা দেবো।
Report.
Well, I have served pursuant to lordship direction. I have served upon respondent number 6 and 7. Well, they have received and the track report has also been annexed. Kindly see the affidavit of service, my lord's last 2 pages.
Today I'm afraid I cannot take up the matter in their absence. You have a resolution to. Let me fix a date. Affidavit of service. None appears for respondent number 6 and 7 despite service. Paragraph, let the matter appear under the same heading on 16th May. Next.
729.
May please, my lordship, Lord.
Respondents? Anyone for the respondents?
For the respondent.
Yes?
Number 1, my
Respondent number 1, who is appearing? Union of India.
I'm for the
One is a union. Lord,
Highways authorities.
Lord, union is represented. State is represented.
National Highways.
7 is represented. National Highway.
Is there?
Monica.
Yes.
Lord, everyone is here.
Pro forma respondent not required.
He is appearing.
Yes, what is the matter?
Lord, I am a tenant of a property. Lord, that property was sought to be acquired under the National Highways Act.
Lord, notification under 3A was issued. Lord, then 3D notification and 3G one stage is also complete. I made representations, my lord. I am praying before your lordship, my lord, for consideration of my representation. No, I am the tenant. I was running a business, but no compensation has been either calculated or paid to me. The landlord has got his share and he has not, he is no longer perhaps would be interested. But I had a running decorator's business.
Where is the representation?
Lord, I have made two representations, page 75 and page 78. It's already demolished.
Yes, he has to be granted. 75 and 78 are both, let both be considered in that.
Yes, my lord.
Before the land acquisition officer, my lord, he's represented before the land acquisition, special land acquisition.
He is the special land acquisition officer.
The special land acquisition officer has to consider.
Yes, yes. I'm grateful to you.
The petitioner claims to be a tenant in respect of the plot in question, which has been acquired by the National Highways Authority of India and award granted to the, a compensation paid to the owner
Former respondent number 7.
under section 3G1 of the Act of 1956. Stop. The petition, 1956? Act of 1956. The petitioner submitted representations before the concerned authority on
Date gulo bol na অপূর্ব জোসেফকে ডেট গুলো বল but I'm so sorry lord, I'm telling you lordship
October 2022 and 28 December 2023 respectively, seeking compensation as occupant / tenant of the property in question. Stop. The representations are yet to be considered. Stop. The petitioner seeks a direction upon the authority to consider the representations at the earliest. Stop. Paragraph. Learned counsel for the respondents
Number 4,
submits that
number 4.
fourth, the fourth respondent be directed to consider the representations in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representations submitted by the petitioner dated such and such due to the date given respectively within 1 month, within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law.
আমি কি আপনার বিরুদ্ধে কিছু বলতে পারি
In the event the petitioner is found entitled to compensation, comma, the concerned authority shall, the said authority shall take necessary consequential steps within 2 months thereafter.
যা আছে তুই গিয়ে আবার ওদিন জমা দিয়ে দিবি দরকার
Yes, next.
কত দেবে কত
These are this bunch of matters.
সবাই অ্যাপিয়ার করছে Lord, 730 to 753 are all similar matters. So if my lord is satisfied with one matter, same order may follow
You are appearing for?
for the petitioner.
You are appearing for?
So Das is the petitioner, my lord. He has asked me to, my lord, assist your lordship, my lord. Lord,
But are the respondents present today?
National Highway State. Yes, they're
huh?
731 I appear for.
No, 730.
This is 730. Let me deal with one matter first.
730, no one is for the state, I will.
730, Mr. Day is for the state. No, I can't take up.
No, I will not insist. I will not insist.
None appears for the state respondents.
Lord, may I beseech you also to do one thing? My lord, kindly do not pass any order in all these matters. Let us all come back on Monday for the bunch of matters because in piecemeal it will be difficult. In piecemeal, then it will be difficult for us for the court also.
Ensure appearance of the state or
I will inquire who is engaged.
know who is there.
I will inquire who is engaged and come back. Not only one request to the court, my lord. There are
7:30 you're appearing. That's good. Yes. So please make your submission. The hurdle is crossed. Yes.
Affidavit of service. Lord, Lord, kindly come to Lord, kindly come to page 79 of your Lordship's brief.
79.
Lord, on absolute similar facts and circumstances,
What is the
Justice
matter?
Chaudhary, Lord, I tell you, Lordship, Lord, 2013 acquisition,
Oh,
post
this is a earlier
2013.
order.
Yes, 2013 acquisition, but the compensation are calculated under the National Highway Act. That's the first case. Lord, absolutely similar circumstances, Justice Chaudhary has passed this order with regard to Lord the same locality. Your Lordships have extended that interim order on two occasions. Lord's affidavit file hoyeche mamlata. Affidavit has been filed by the state in that matter, but it was a order was passed on contest and upon hearing the state and the National Highway. Lord, may I place the order for your Lordship's kind consideration? Lord, kindly take from the second paragraph. It is a case of the petitioner that as per the National Highway Act, Section 3G1 provides that where any land is acquired under this act, there shall be paid an amount which shall be determined an order of the competent authority. Subsection 5 of Section 3G of the said act states, if the amount determined by the competent authority under subsection 1 and 2 is not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government. Then subsection 7 of 3G, the competent authority arbitrator will determine these are to be considered. Then my lord may skip over this paragraph. It is submitted by the learned advocate on behalf of the petitioner that after taking over the land by way of acquisition, the competent authority of on his own whims and caprice determined the value of the land and structure. The petitioner was compelled to move the arbitrator for enhancement of land. It was enhanced by the arbitrator. However, the enhanced money has not been paid to the petitioner. The copy of the award has not been served to the petitioner. Learned advocate for the petitioner also submit the provisions of Section 38 of the 2013 Act. No acquisition of land is before payment of compensation, as well as rehabilitation and resettlement entitlements are paid by the to or tendered to the entitled person. It is also submitted that the petitioner is not entitled to get compensation for the land which is intended to be possessed, but he is also entitled to compensation for the structure which has eventually been lost due to the acquisition. As per second schedule of 2013 Act, the petitioner is entitled to get an alternative house for land if the land in question is under development, cost of development of land, choice of entitlement, and infrastructure amenities as provided in the third schedule. The said entitlement of the petitioner is beyond the scope of determination of the compensation by the arbitrator on 3G5 of the NH Act. Until and unless such relief is granted to the petitioner, the collector cannot acquire the land and hand it over to the requiring body. Mr. Sen, learned advocate for the state, Mr. HON'BLE Sen appeared, has submitted the statement of fact regarding computation of compensation in respect of the land and structure of the petitioner. It is found from the said report that the provisions of right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 was duly considered and the amount of compensation was fixed by the collector for the land and structure. The petitioner was dissatisfied and moved the arbitrator. Arbitrator enhanced the award for the land and structure. The state respondents are in process of payment of such compensation. Thus, it is submitted from the statement of the fact that total compensation has not yet been paid to the petitioner. Secondly, the petitioner has not been granted the relief of rehabilitation resettlement as per second and third schedule of 2013 Act. Determination of compensation in respect of second and third schedule is not within the jurisdiction of the arbitrator. In view of such circumstances, this court holds that the instant writ petition is prima facie maintainable. The instant writ petition shall be disposed of on exchange of affidavits. Therefore, the state respondents are directed to file affidavit within 2 weeks from the vacation, after vacation, and serve copy of the same. But perhaps belatedly they have filed the affidavit. The petitioner is at liberty to file reply. Lord, kindly take the next paragraph. Since Section 38 creates a bar against taking possession of the acquired land before the payment of the entire compensation amount, if the land in question is in possession of the petitioner, as on this date, status quo in respect of such possession shall be maintained by both till 15th of December. And this has been extended by your lordships twice. Now, my lord, kindly apropos to this, take page 52. Page 52. Lord, kindly have a look. I'm so sorry, Lord. I'm so sorry. Lord, kindly have a look at the LA case number 14 National Highway 81. Then kindly see what they are saying. এত দ্বারা আপনাকে
The same in a case.
same LA case. Same LA case. Rindam, you have checked up, right?
The number is not recorded in the order, isn't it?
You have checked up. Mr. Das says, Lord, it is the same.
NH 81, your lordship.
Yes, he has checked it up. এত দ্বারা Lord, kindly have a look at the year 2015-2016. So it is post Lord 2015 when this act was not given effect, the schedule. First, এত দ্বারা আপনাকে জানানো যাইতে যে উল্লিখিত বিষয় যেহেতু আপনাকে স্বার্থযুক্ত ব্যক্তি বলিয়া গণ্য করা হইতেছে, সেহেতু আমি 1956 সালে জাতীয় সড়ক আইনে 3G ধারা উপধারা মোতাবেক ক্ষতিপূরণ দেওয়ার ব্যবস্থা করিয়াছি। আপনার অংশ অনুযায়ী আপনি 1366 টাকা ক্ষতিপূরণ পাইবার অধিকারী হইয়াছেন, যা আপনার ব্যাংক অ্যাকাউন্টে সরাসরি জমা করা হইবে। আয়কর বাবদ প্রদত্ত টাকা আগামী 28/3/18 তারিখে বেলা 10:30টায় স্বয়ং রবীন্দ্র ভবন, চাঁচল, মালদা উপস্থিত হইয়া অত্র নোটিশের ফর্ম যথাযথ পূরণ করিয়া জমা দিবেন। পূরণ করা ফর্ম জমা দেওয়ার পূরণ করা ফর্ম জমা দেওয়ার 1 মাসের মধ্যে আপনার আপনার প্রাপ্য ক্ষতিপূরণ আপনার ব্যাংক অ্যাকাউন্টে জমা দেওয়া হইবে। This is the 3G1 notice. Then kindly take another one, page 53. 3G1.
This has to be calculated.
Lord, this same person, this has to be calculated since this is 2015-2016 and section 105 was given effect in 2015. This has to be calculated in terms of the Lord, the Fair Compensation Act. But kindly see, they are paying me. Kindly just again take the pen to come back to
3G5.
My Lord.
You have applied under 3G5.
Lord, I filed an application. They have never served any notice of arbitration. We have not participated. We have not participated. They have never served any notice of arbitration. Now, kindly for a second, if my Lord takes the pen to come to page 52 again, Lord, kindly have a look at only one thing. Kindly see the area 0.2150 acre. That means 2 decimals. But according to them, the compensation is 1366.
If you are not happy with the 3G1
No.
compensation, you have recourse.
Yes.
3G5.
If that was calculated under the 2013 Act, since that Act, the schedule was given effect. Lord, I have twofold submission which was accepted at the prima facie stage by Justice Chaudhary, as has been extended by your lordship the interim relief. Although it is interim, yet to be finally decided. But my Lord, there are certain things which needs to be done at the stage of 3G1 also. According to this statute, that has also not been followed. If my Lord takes the pen to come back to that, Lord, 3G1, 3G5 is both the stages. 3G7 has to be complied with. What are the parameters of 3G7? Those are not appearing
It
at
has
all.
not been done in 3G1. Your recourse is 3G5.
Yes, Lord, I absolutely bow down to your lordship. No,
So only when 3G5 is disposed of,
then I can come to your lordship's court.
then you can go under section 34.
Absolutely, Lord. Yes, then to your lordship's court following the procedures under the Arbitration Act. No notice of arbitration has been received. And Lord, with regard to this,
5 is supposedly still pending.
Lord, the state will be able to inform your lordships. Lord, I beseech your lordships, Lord, if they want to come back with this instruction whether 3G5 is, Lord, pending or not, what they want to do, let them also bring the 3G1 notification.
Award.
3G1 award copy, so that we can, Lord, have a prima facie look
Absolutely.
whether, Lord, the basics have been complied with or not.
Here the
My lord, before that, lordship, lordship, the subject land lordship is NH81, my lord. This NH81 lordship is not being developed or constructed by the NHAI, my lord. That has been developed by the NH, my lord, the PWD NH division, my lord. In the what my learned friend lordship, they relied upon this order, my lord. In this order, lordship, the Justice Chaudhary is already mentioned, though lordship that has not been. If your lordship kindly come, page 86. My lord, though lordship that order has been, my lord, though the Union of India and the competent authority under the National Act are assigned as a respondent number do not have any role, my lord, though lordship they had been totally typographical error, my lord, and my lord has already corrected this portion. The National Highways Authority lordship regarding NH81 lordship has not been any role, neither the acquired nor the requirement body lordship. So lordship kindly.
We want that Miss Rai is overbriefed and busy with the matters. We have made the NHAI party. So earlier also your lordship deleted one of the parties.
Running short of briefs, sir.
No, not the on a lighter note.
It's required
No,
for
not
this
at all.
item.
Sympathy.
I
I
am
have
not
not
at-
seen
I'm-
like my system, Lord. On a lighter note, we have made her party. Your
No,
lordship
no,
has
my lord,
deleted
kindly,
one of
kindly
the
deleted
parties.
my name, my lord, because lordship, I have nothing, lordship, any role regarding this matter.
But
Yes.
your lordship has later on corrected this order
Yes.
by a subsequent order. ওটা কি carry করছো? ওটা একবার দাও। Subsequent order carry করছো?
You are for 2, 3 and 6. My lord, 2, 3 and 6. Let this be expunged. My lord.
Yes, but I don't mind. Your lordship, as Justice Chaudhary has done, your lordships have corrected this order. Lord, I
What
just want to
correction?
show your lordship the corrected order so that Lord this
Corrected which order? My lord,
your lordship has
this order.
corrected this order because
Because lordship, in this order, lordship, that has been recorded, the competent authority does not have any role instead of NHI. So my lord has already corrected this order.
this is the corrected order. So if your lordship expunges their name on their prayer, my lord may have a look at this subsequent order and may pass that order. I don't mind in that. If they themselves say they don't have any
Yes, I have no any role. Why should I?
Justice Chaudhary's order, page 79, Lord says that
This is in the other writ petition. No, my lord, regarding this other Shram, my lord, what my learned friend is relying upon, lordship, page 86 of this writ petition.
not come to page 79.
No, but this is with regard to that earlier writ
My lord. Yes.
correction. My lord.
The correction. So I am just bringing it to your lordship's notice so that Lord, the proper party may be.
Correct. The project director only has been implicated.
Yes, yes. Format. Project director is respondent number 6.
So here it is not expunged. It was only a submission that it may be expunged. My lord, why lordship? I have no any role, lordship. There is any lordship in. My lord, kindly recorded lordship, and my submissions can be recorded. Expunge. My lord. I don't mind. Role, why should I? Let me expunge the National Highways Authority because it is completely on your. Yes.
Well, I'll have to take the instruction regarding the arbitral notice
And
as
the
well as
3G1 award. Whether it has been served. Yes.
And to produce copy of the 3G1 award that they let them produce.
Will you come back with a report in that case?
Yes.
Annexing these documents.
In that matter, my lord, paragraph 7, they said they file the
Yes.
Award. Application
Yes.
filed, but no notice was issued.
I have annexed that.
that is another thing, my lord.
No. In all the matters, they say that they have
Yes.
filed 3G5 application, but no notice of arbitration has been issued. So I would like to see whether arbitration has been held at all.
No, I'll come back to that.
Lord, only one prayer to your lordship. Lord, kindly protect our interest till they come back with this.
Here I join an issue.
Because Justice Chaudhary has page 82 last paragraph.
Cannot be treated as precedent.
Page 82 last paragraph protected our interest, my lord. The order records that status quo in respect of status quo.
Here, Malad, this is a
You come
development
back with
project,
a
Malad.
service time.
Malad, they are only entitled to get the compensation. Either today, Malad, they are unhappy, or tomorrow they will get the
But January we served it on Mr. Thor.
development.
I think there is substance in what Mr. Dhar is saying.
Lord, January we served it on him.
All the development project.
Lord, if it is not,
Best entitled to compensation.
Lord, this interim order that they are suffering, not prefer any appeal, it is extended for thrice. It is extended thrice. Lord, kindly appreciate only one thing. May I just take 1 minute time, Lord, for him.
Her learned affidavit.
Lord, then if in the meantime my structure goes, I'll be in difficulty.
Yes.
If my structure goes,
If your structure goes, you'll be attached to compensation. for
Lord,
it.
there has to be, Lord, that has to be, Lord, see calculation, calculated.
Authority of India submits.
That
Since
Lord, let him come back within a week.
NH 81,
Accept us.
it's NH 81. This is the subject matter of the writ petition is under control and supervision of the state authorities, the National Highways Highways Authority has no role to play in the present writ petition. Learned Counsel seeks The learned counsel requests expunging of the names of respondent numbers 2, 3 and 6. 2, 3 and 6. The cause title of the requisition. Paragraph. In view of the above, the names of respondent numbers 2, 3 and 6 be expunged from the cause title of the requisition. The cause title be amended accordingly. Grateful. Paragraph. Learned counsel for the petitioners submits that being unhappy with the award under section 3G1 of the National Highways Act 1956, they filed an application under section 3G5 of the Act. Stop. No notice of arbitration has been issued upon them, and also, award declared under section 3G1 of the Act, a copy of award declared under section 3G1 of the Act has not been served. Not been served. Paragraph. Learned counsel for the state respondents seeks to submit a report in the form of affidavit annexing relevant documents demonstrating relevant documents as to whether notice of arbitration has been served upon the petitioners, arbitration has been held upon hearing the petitioners, and also the copy of the award under section 3G1 of the Act.
Lord,
Let the matter appear under the same heading. When will you come back?
Lord,
Within which time?
now let us come back on 19th.
Not 19th. That will be my last. I'll go for the circuit bench for 2 weeks. So please come back after that.
Lord, then
Will you come back on 10th May?
Lord, till such time, let them not. If they have not done it, let them not do it, because otherwise.
Kindly, my lord, this is
I am not passing any interim order. Please come back on 10th May. The same order may be passed in all the other matters.
My lord.
NHA, my lord, will get Union of India also.
No, Union of India is required.
Why?
2013 Act is Central Act.
Remain, let us see.
In respect of item 731, I appear for
The same order.
All these matters are same, my lord.
You are 3 and 6 in all the.
My lord.
You're sure?
My lord. All the matters, my lord.
So all the same order in all the matters. Please come back.
Lord,
to
I
the court
am giving you.
showing whether 3G5 has been disposed of upon hearing the petition. That is very important.
Lord, I am giving you Lordship's officer, Lord, the numbers. There are 34 matters, Lord. Starting from
Tell me one by one.
Lord 730 to 753.
730 to 753. Yes.
And Lord.
Same matters.
Lord 582.
582.
No, Lord 456.
Let it be till 753.
Because when we mention
730 to 753, same order.
Separate order.
Come back. Of course, separate orders. Alag-alag order. Read now. Names. No. State alag. Please give individual name.
Lord, when we mentioned those 3 matters also before my lord, it fell from your lordship's, my lord, when the matter.
Let me deal with these matters. It will automatically be covered. Let me deal with these matters.
তাহলে আমরা তো ওই প্র্যাকটিসই শিখেছি, কি পারফেক্ট হবে বুঝতে পারে।
Yes, call the vote.
স্যারের আগে হাত
Motion group 7, item number 760.
আমাদের কত আছে মনে হয়?
My lord, in this matter, I have filed the NOC.
You want to appear in person?
My lord, pleadings are complete. Report has been filed. Exception has been. My lord, in this writ petition, I have challenged the Director of Transport order, which was passed pursuant to your lordship's order at page number 51 of my writ petition. লাগবে না in person.
Yes.
My lord, in this order, my lord, the same was disposed of with a direction upon the Director Transport to dispose of the representation in accordance with law after hearing all the stakeholders. My lords, thereafter, my lord, impugned order is at page number 58. My lord, I am aggrieved with paragraph 6 and 8 only. To the extent of paragraph 6 and 8, I am not aggrieved with the memo issuance, my lord, and my lord, not with the entirety of the order. My lord, your lordships may recollect in 100 plus writ petitions, your lordship has been pleased to pass an order subject to being different. The registration ought to be accorded. My lord, here only the Director of Transport has omitted the subject to being different, and he has directly declared it's different. That is the main issue. My lord, paragraph 6, the impugned order, there was no paragraph mentioned, my lord. So I'm reading the impugned provision para.
It is revealed.
It is revealed that petitioner company is an automobile manufacturing company which manufactures electric three-wheelers, e-cart and e-rickshaw, and petitioner submitted documents that the battery of electric three-wheelers manufactured by the MBS Kinetic Green Energy and Power Solution Limited is lead acid battery, which is different. My lord, it must be subject to being different. That the battery, which is the subject matter of title suit number 27 of 18 of learned additional district judge, South Chobis Pargana, the petitioners also submitted that e-vehicle manufactured by them comply with the rule 126 of the Central Motor Vehicle Rule 1989. My lord, I am aggrieved to the extent of subject to being different.
Submission of the petitioner, not the observation of the authority.
My lord, thereafter, may I take your lordship?
No correction is required here.
My lord, may I take your lordship to subsequent para number 8, my lords? Due perusal of the relevant paper, my lord, produced by the petitioner and following the solemn order passed by Honorable Justice SUVRA GHOSH, Calcutta High Court in regard to 67 cases, similarly placed pertaining to the same subject matter dealing with the instant case, it appears that battery used by the petitioner is distinct and different. My lord, it must be subject to being different and distinct, which was observed by your lords. My lord, thereafter.
The authority has held that it is distinct and different.
No, my lord, there was a additional secretary order is there. My lord, may I take your lordship to the additional secretary letter dated 29/3/2022.
This was heard in your
Page number 40.
The matter was heard in your presence?
My lord, heard in my presence, I have submitted the written submission that was not considered. My lord, I am coming to that point also, my lord. My lord, may I take your lordship to page number 40 of my writ petition?
Yes.
My lords. My lord, I am reading the second paragraph of this letter. I am also directed to inform you that although the Honorable High Court passed an order dated 18/2/2022 and granted liberty to the registering authority to consider all the relevant material with regard to the pending proceedings in TS 27 of 2018 at the time of registration, but practically it is not possible to assess the technicalities as department does not have the technical expertise to differentiate between the EV technology used in the vehicles, e-carts or e-rickshaws vis-a-vis that prohibited by learned additional district judge vide his injunction order dated 24/2/2020. My lord, this letter was challenged in the coordinate bench, and this letter was upheld, my lord. It was not quashed by the coordinate bench. My lord, the government is saying, additional secretary is saying they don't have the technical expertise, and director is part of the government. Director is the officer of the government. My lord, they cannot go beyond the dictum which was given by the government. My lord, thereafter, may I take your lordship to the impugned memo, page number 60.
60.
My lord. My lord, in the impugned memo, kindly sees authorities in this are allowed to be registered by the registering authorities in this state subject to the said vehicle. Subject to the said vehicle being different. My lord, in the memo, subject to the, my lord, this memo has been issued pursuant to that impugned order, and in the memo they are admitting subject to being different. And in the order, my lord, paragraph 8 is the observation. Paragraph 6 is the submission. I agree.
You have filed a review application before the authority because the writ court will not correct an order given by
My lord, I most humbly agree with this, my lord. My lord, I'm placing this, what has happened. Thereafter, whatever falls from your lordship, I will.
What is asking for in the writ petition? What is your prayer?
My lord, my prayer is to expunge the paragraph 6 and 8. My lord, what falls from your lordship, that paragraph 6 is the submission. My lord, let it be there. If it is submission, it is. Paragraph 8 is the observation, my lord. That has to be expunged.
Cannot be expunged. You have to ask for a review. Maybe the authority has missed.
My lord, so that I will do, my lord. My lord, one more thing, my lord. I would like to
hear the state.
My lord, one more issue, my lord, I wish to bring to your lordship's kind attention, my lord.
Let me see your prayer.
My lord. My lord, I only seek for the expunging of that paragraph 6 and 8 in my prayer. To that extent, I am not agreed with the memo, and I am strictly on the subject to being different terms, which was passed by this court. My lord, in the report, my lord, the state has filed. May I take your lordship to the report, my lords?
Yes. Yes.
My lord, the state has said, in contravention to its own government order, in paragraph 18. My lord, kindly cease, my lord. I respectfully submit it is not necessary to have technical expertise. My lord, kindly sees additional secretary, which is senior in hierarchy, saying that this department does not have the technical expertise. And director in its report at paragraph 18, in deliberate violation of that observation and in contravention to that observation, saying that they does not require the technical expertise. My lord, this is the submission of the director. My lord, thereafter my exception, my lord. May I take your lordship to my exceptions? My lord, in my exception, may I take your lordship to page number 10, coordinate bench order.
Yes.
My lords, page 10 of my exception, my lords. My lord, in paragraph, I am reading the paragraph 2. This order was passed by His Lordship Honorable Justice Somensen Lordships in presence of his State Council. The names are appearing, my lord, in page number 9. Herein, High Court has observed the court has come to prima facie findings on 17 June 2015 that plaintiffs who are the writ petitioner in this procedure. My lord, at page number 10, para 2, my lords.
Page number 10, para 2 is the court has come to a prima facie finding.
My lords. On 17 June 2015, that plaintiffs who are the writ petitioners in these proceedings are holders of patent in respect of technology applied for battery operated e-rickshaws. My lord, this is the main important thing which was observed, prima facie observed by the Honorable High Court. My lord, thereafter, may I take your lordship to page number 12, my lord?
Yes.
My lord, just see how state is changing its color. My lord, in this order, my lord, your lordships has been pleased to pass a consent order wherein, in respect, subject to being different and distinct, registrations has been ordered, my lord. My lords. Thereafter, my lord, may I take your lordship to page number 19? My lord, this is all happening after filing of this writ petition, after passing of this impugned order. the director of transport who has sworn this affidavit before this court that they don't want technical expertise, they have filed a written objection before the Lanet Alipur court in the contempt proceeding. My lord, the most important thing, at one hand, they are saying different and distinct, and on the other hand, at paragraph 14, page number 23, my lord, they have said, director has stated, it is also submitted, respondent did not order the registration of e-vehicle of Symphony Auto Trader without the license of the petitioner. My lord, sees the conduct. Change of stand. Before the coordinate bench, prima facie observation was there that I am the holder of the technology operated for battery operated e-rickshaws. My lord, I'm sorry.
Yes.
My lord, that was state was aware of that order because the state representative was present. Secondly, my lord, before this honorable court with regard to Symphony, subject to being different order was passed. Similar memo was issued and director has taken this stand at page number 23, paragraph 14, that they don't order registration without my license. My lord, three type of stands. And now they are saying a new stand, they don't require a technical expertise beyond contravention to their own secretary letter, my lord. So, my lord, I most humbly pray for expunging the paragraph 8, my lord, because it's jeopardizing the injunction order and it's superseding the Honorable High Court's observation of your lordships as well as coordinate bench, because your lordship has been pleased to direct subject to being different. And coordinate bench has ordered that I am the holder of the technology. So, my lord, both thing has to be done by the registering authority. And director has no power under section 213, and director has no power to supersede the judicial observation, my lord. My most humble submission with regard to this, my lord.
Let us hear the. Yes. You are appearing in this matter?
My lord, I am in a thing, my lord, another matter is being called before, my lord, justice. After two matters, my matter is here also. I was asking how long my learned senior branch will take. My lord, I shall be.
Lord, you kindly see the improvement order, page 60. Is the outcome of the hearing took place pursuant to my lord's order. Hearing was took place, that is page 58. He has shown, and ultimately order was passed in compliance with the aforesaid order, lordship policy in compliance.
58 is the order.
58 is the hearing observation. That is not, that is main.
58 is the order. The
58
representation is considered and allowed. 59.
Yes, sir. 60 is the improved order here.
It's not the order. 60 is a communication.
60 is the communication.
Order is 59. 58 and
Order 58. My humble submission, my lord. What my learned friend, what is prejudice by my learned friend? First of all, what is his prejudice?
the language of the order.
What is the prejudice? Because his battery, his patent is not disturbing. Patent is no way disturbing.
No, but can the transport director pass an order in contravention of the order of the secretary?
That is my lord departmental. That is the additional secretary.
Additional secretary says that the department has no expertise to consider whether they are distinct and different.
Well, the transport director, after considering the certificate issued by the appropriate authority of the department, then my lord issued that here. Lordship kindly see my report. That is better.
Yes, report paragraph 18 is also contradictory.
I am coming. Lordship kindly see, my lord. the paragraph 10, paragraph 9 first, the paragraph 9 first, inasmuch as the patent earlier, my lord, the Pahon portal, his name was not recorded in any way, anyway, that is, inasmuch as the patent obtained by the writ petitioner is concerned, it would be apparent from the website of the Office of the Controller of Controller General Patent Design and Trademark Department of Policy and Promotion, Ministry of Commerce and Industry, Government, that the petitioner has registered and obtained patent in respect of a fuel system and an efficient, eco-friendly vehicle mounted with fuel cell system. That is, the obtained order injunction, transfer, my lord, we are not with that. Subsequent to the order, transport of the granted different additional district judge. But every order, my lord, additional district judge order must be complied with that.
Paragraph 80.
Paragraph 80.
The additional secretary says that there is no expertise in the department. The director says that no expertise is required at all. Who is correct?
আপনার ম্যাটারই চলছে।
That is my lord.
It's contradictory.
It's contradictory.
Who is correct? One of them should be wrong.
One of them should be. In a particular case, my lord, when the certificate, when after going through the certificate, wherein can you see annexure R2, where category mentioned that a fuel cell system and an efficient eco-friendly vehicle mounted with fuel system. Grant title, that is the patent, is patent.
And
That
how
is on the basis of the patent, Director Miller passed an order that he has not, and the issue by kinetics, that is petitioner, there the petitioner measures kinetic green energy, use a different fuel system.
Why does the additional secretary say that there is no expertise if it is not necessary at all?
No question, on the basis of the document, on the basis of the expertise document, proceeded on the basis of the expertise document, not here, not.
But the additional secretary doesn't say so.
Additional secretary, no, not this case, generally.
Inclusive. It's
Generally
inclusive.
says.
Isn't it? This case is also included.
After the additional secretary,
It's a general order. This case is also included.
my lord, I am not, one of the
Only the limited prayer of the petitioner is in paragraph page 59. Please come to this, the first paragraph of page 59. Third line, the authority says, page 59 of the writ petition. It appears that the battery used by the petitioner is distinct and different. How did he come to this conclusion?
That is paragraph 6, page 58.
Page 59. No, paragraph 6 is the submission.
Submission.
That is all right. The first paragraph of 59.
Due perusal of the relevant papers produced by the petitioner and following.
Third line, it appears.
Yes. Similarly, placed pertaining to the same subject matter, it appears that the battery used in petitioner is distinct and different from that day of battery, which is the subject matter of TS number 12.
How does the director hold this?
Director says, well, on the basis of the record.
Where is it stated?
On the basis of the record.
Where is it stated in the order?
That is not the, that is well called, but that is on the basis of the patent record. That is my report is there. On the basis of the report, we find that there is a difference. After obtaining the certificate record, then we found that.
Paragraph
It is not his opinion. It is not his opinion. On the basis of the R2, Annexer R2, this is the certificate issued by the authority, concerned authority.
Where is
After
R2?
perusing that, Madam, R2 is my evidence report, my district. On the basis of the certificate which is produced by the petitioner at the time of hearing, grant title 1, 2, 3, 4, 5.
This is the petitioner's patent.
Petitioner, kinetic energy. That he is the different.
Petitioner.
No, kinetic energy here.
R2 is the petitioner's patent.
Yes, it is the repeater, present repeater. That is the patent. That system was not incorporated in the kinetic energy, which is challenge here. I do not know why he has not made party to him. It is not the opinion of the directors.
Oh, battery manufactured by Messrs. Kinetic Green Energy is lead cell battery, which is different and distinct from the battery of the. So what is wrong in it? Mr. Sinha?
My lord, my learned friend is making submission which is rehearsed to his own letter, my lord. First of all, they have the power to state this. They have the power to go beyond, supersede the coordinate bench order and your lordship's order. My lord, my learned friend is saying that on the basis of patent, director is saying this. But what the court's order says, court order says in kinetic matter that you decide the representation in accordance with law after hearing all the stakeholders. That's what the order of kinetic green energy says. And pursuant to that, this impugned order has been passed. My lord, thereafter, additional secretary is saying, I don't have the technical expertise. It means government does not have the technical expertise.
Even
So,
if that is correct,
my lord,
this authority says technical expertise
my
is
lord,
not required.
my lord, secondly, my lord, this authority is the party before the civil court, and they have filed a written objection in the civil court that they haven't ordered registration of electric vehicles without my license. First, second, no one can be judge of its own case. That is the principle, my lord. Secondly, my lord, they are taking this. Their director is passing an order saying that battery is different, and coordinate bench is saying petitioner, writ petitioner is having the patent over the technology of electric vehicle. Your lordship is saying subject to being different. Your lordship's order is matching with the coordinate bench order.
Yes.
That's why I have consented, because
They have-
coordinate bench says
Then the
that,
order holds that they have seen from the document
my lords,
that it is different and distinct.
my lord, they cannot say this because under section 213, they don't have the power at first. Secondly, they are the party before the civil court. No one can be judge of its own case. Registering authority must do this because director, what the court has directed to the director to direct the registering authority subject to being different, registering authority will register the vehicles. How director can?
The direction was on the transport director.
My lord, direction upon the transport department director, I most humbly accept. My lord, but what was the purport of the direction? The purport language used by your lordship. My lord, may I take your lordship?
Registering authority can decide whether it is distinct and different.
My lord, director is not the authority. Secondly, my lord, may I take your lordship? My lord,
The direction was in the writ petitions, the director to direct the registering authorities to register.
No,
the
here, my lord,
page number 47.
Consider and dispose of the matter.
My lord, page number 47.
Page
I am taking your lordship to my exception, my lord, my exception.
But every
in my exception, order is annexed at page number 15.
Now we are showing the 2015 order, 12th order.
My lord, in Symphonil, one of the writ petitioner's case, accordingly, writ petition page number 13, I am reading, my lord. Accordingly, writ petition is disposed of my exception. Page number 13 of my exception.
13(1)(3).
My lords.
Yes.
See the exact language, my lord. Accordingly, writ petition is disposed of directing the Director, Transport Directorate, being sixth respondent herein, to issue necessary direction upon the concerned regional transport offices to grant registration to e-rickshaws manufactured by the petitioner, subject to the said vehicle being different and distinct from the vehicle. Means registering authority will do. This was the clear order passed by this court. My learned friend has kindly sees this was the language used by the court. Director is not authorized to do so.
The present case.
You are not authorized. In
order.
the present
What is
case,
the matter?
representation was directed to be
Yes,
considered in
yes.
accordance with law.
Yes.
You are not even directed to do so. How you have done? You are not authorized under law. You are the party before the civil court.
Maybe.
Secretary is taking.
This hearing was not called in terms of this order.
My lords.
For exception, it was called in terms of the order at page 52.
My lords.
And page 52, and this is not the same direction.
No, no, I am not saying so, my lord. My lord, this was your lordship's order
So
directing the director.
Cannot refer to this order here.
My lord, just for the information purpose only.
Not necessary.
My lord.
Disposed of directing the third respondent to consider and dispose of the representation.
My lord, and one more issue, my lord, I brought to your lordship's kind attention. My lord, my lord, there was a consent between me and the kinetic energy. Consent was recorded, and I have annexed that letter also, and that consent was also not taken into consideration by the director.
For reconsideration.
My lords, let there be a reconsideration depending upon the consent letter which I have sent, annexing the writ petition also. My lord, that was communicated to the director. Director has deliberately not taken into consideration those facts, my lords. My lord, consent letter is at page number.
No document has been referred to in the order impugned. So let the director reconsider. Because director is to give direction to the respective registering authorities to consider whether it is distinct and different from the patentee's battery, and then
that is my lord. Several order was.
My lord, page.
Mother order.
This is the mother order. But here, my lord, in this case, my lord, only director.
Representation, but then the director will consider all the documents placed.
All the documents, my lord, case and all the documents considered regarding, my lord, that the authority has issued the order. On the basis of that order, the order has been issued. No question of any violation.
My lord, page number 50.
No question of violation. Let it be reconsidered.
That is, my lord.
My lord, in the light of page 50, because page 50 I have communicated to the director, and that was not taken into consideration by the director. In my writ petition, my lord, page 50.
My lord, I do not.
My lord, when me and the writ petitioners are agreed, then what director will do?
Why the writ petitioner? Why you have not made party?
They are the party. Writ petitioner is the party in the writ petition. Kindly sees the cost titles. My lord, without seeing the cost title, my learned friend.
You say it will be filed before this court.
My lord, it was filed before this court, and we have agreed that consented in terms of order dated 5/12, and this letter was also given.
You can produce relevant documents before the authority. Let them reconsider. Heard learned counsels for the parties. Paragraph, it is contended on by the petitioner in person, that the petitioner is agreed by paragraphs 6 and 8 of the order passed by the director, transport department, government of West Bengal, transport directorate, government of West Bengal, on 14th June 2023, allowing the representation submitted by Messrs. Kinetic Green Energy and Power Solutions Limited, comma, writ petitioner in an earlier writ petition being WPA 8995 of 2023. Stop. By an order passed on 10th May 2023 in the said writ petition, comma, this court directed the director to dispose of the representation submitted by the petitioners therein before the authority within a stipulated time frame upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners and the private respondents in the said writ petition. Paragraph. In the order impugned, comma, the director has held that upon perusal of the relevant papers produced by the petitioner, comma, it appears that the battery used by the petitioner is distinct and different from that of the battery which is the subject matter of the title suit. Paragraph. Learned counsel for the petitioner submits that the order impugned was recorded without taking into consideration the documents placed by the petitioner before the authority. Stop. The director was only authorized to issue necessary direction upon the concerned regional transport offices to grant registration to the e-rickshaws subject to the said vehicles being different and distinct from the vehicles forming subject matter of the title suit. Comma, meaning thereby, comma, that the respective regional transport officers were the authorities to opine whether the vehicles whether the battery used in the vehicles before the authorities were distinct and different from that of the battery which was subject matter of the title suit. Stop. The director had no authority to hold the same in the order impugned. Paragraph. The petitioner seeks it is contended on behalf of by the petitioner in person. The petitioner seeks reconsideration of the representation upon granting him an opportunity to place all relevant documents before the authority and making relevant submissions. Paragraph. Upon consideration, it appears from the order impugned that though the director has held that on perusal of relevant papers, it appears from the order impugned that the director has held that on perusal of relevant papers produced by the petitioner therein, within bracket, Messrs. Kinetic Green Energy, bracket closed, it appears that the battery used by the petitioner is distinct and different from that of the battery forming subject matter of the title suit. Stop. Though this petitioner claims to have produced documents before the authority, comma, there is no whisper in the said order as to whether such documents were taken into consideration by the authority while considering the representation of the of Messrs. Kinetic Green Energy. Also, comma, it appears from several orders passed by this court in this connection, in this regard, that the director was directed to issue necessary direction upon the concerned regional transport offices.
Registering authority.
I'm reading the language, stating the language of the order.
Registering authority.
To grant registration of the e-rickshaws, subject to the vehicles being distinct and different from the vehicles forming subject matter of the title suit. Stop. Therefore, it was for the registering authorities to determine whether the vehicles placed before them for registration were whether the batteries of the vehicles placed before them for registration batteries of the vehicles placed before them for registration were distinct and different as recorded in the orders of this court. Paragraph, in view of the above, this court is inclined to hold that the order impugned is bereft of reasons and consideration and is required to be set aside. Paragraph, let the entire order be set aside, let there be a fresh consideration. Paragraph, the order passed by the Director, comma, Transport Directorate, comma, Government of West Bengal on 14 June 2023 is set aside. Paragraph, the director, comma, being respondent number?
My lord, respondent number 3, my lords. 3.
Being the third respondent herein, comma, is directed to revisit the issue upon granting reasonable opportunity of hearing to the persons to all concerned, Kurun, to all concerned, including the petitioner and Messrs. Kinetic Green Energy, and take a reasoned decision within 6 weeks. Within 6 weeks from the date of communication of this order. Stop. The petitioner shall be at liberty to produce relevant documents in support of his claim before the authority at the time of hearing. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of, rejected.
My lord, the merits of the matter has not been gone into by this court, and authorities, all issues may be kept open.
It is made clear. It is made clear that this court has not gone into the merits of the matter. and the concerned authority shall be at liberty to deal with the matter independently and without being influenced by any observation which may have been made in this order.
Great.
Next.
My lord, these matters have been dismissed because disposed of already, my lord. I am applying for respondent of 1, my lord.
This matter is disposed of.
Yes, it is a group 9 decisionary matter, my lord. With regard to the Panchayat election.
Excellent. You are the petitioner.
No, respondent of 1.
Mr. Roy is the petitioner. And he's dreaming away.
No, no, no. What matter? The election petitioner, no, it. Lord, someone is Amarnath Sukul or like that as a petitioner advocate.
Yes.
Amarnath Sukul or, you know?
Union of India, Mr. Manobendranath Bandyopadhyay.
762, my lord. That is of Gurdeep Sethi.
761 ভুল ফাইল দিয়েছেন তো 762 wrong file was given to me. Please wait. It has been released already.
Disposed of, my lord, already. It's a issue that relates to the Panchayat election, my lord.
দিদি ওটা ডিসপোজ অফ হয়ে গেছে বলছেন উনি দেখে নেবেন পরে 762 ডাকুন ওটা কেটে দেবেন তাহলে ডিসপোজ অফ হয়ে গেছে ফাইল নেই তো
Slip দেবো?
ফাইল নেই তো ফাইল নেই তো তাহলে কেটে দিন
Grateful, my lord.
আমার কি আমাদের হয়ে গেছে
Yes.
I have already played.
My lord, Dhiraj Trivedi is late. Busy.
It's not there. So what submission will you make?
My lord, so far this matter is
Order.
my lord, may I say one thing, my lord? This is a matter, my lord, I have already placed my submission. Lordship has recorded my submission. And I have also used certain authorities because they have challenged the maintainability of the writ application on the ground of alternative remedy. So in that context, my lord, and along with the marital, I have placed my case. So now it's up to them to give a reply.
Let me fix a date.
My interim order is till 31st May.
May. Yeah, in April.
May of the
May.
Well, then in any case. Oh, I thought it's April.
Kindly fix it on Tuesday.
After in May. On prayer of the
কবে আছে May?
respondents, the matter is adjourned.
May.
Paragraph, let the matter appear under the same heading on 14th May.
Yes, wait.
Next.
763, I beg to appear for the petitioner.
Your lordship,
Your lordship's order dated 19th February, state is supposed to submit a report.
Your lordship, I have the affidavit in the.
You're
Yes,
appearing
yes.
for state. Have you
May-
served a copy?
May I serve a copy?
Now,
Lordship, it was my difficulty, your lordship. I had a fractured leg, so I had.
going to use an exception.
Lord, I don't know what is there in the
Okay,
report, my lord.
go through it and come back. Report in the form of affidavit submitted on behalf of the fourth respondent is taken on record. Paragraph copy of the report is made over to learned counsel for the petitioners in court this day. Paragraph on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17th May.
Lord, in the meantime, liberty may be given to,
Act and add code
if required, my lord, if necessary.
reported body. On prayer of the petitioners, liberty is granted to use an exception to the report. Please serve an advance copy.
I shall.
Next.
Grateful, your lordship.
I am appearing for the petitioner, appearing with Kakuri Dotto. Last occasion, my junior took time to file, exception. But unfortunately, the petitioner will affirm he met a serious accident, So I do not know whether law will permit me to pray that my advocate undercut may be permitted to put on signature. Number one. Number two, on merit, this is the pith and substance of the matter. Your Lordship is well aware that Kolkata and surrounding area, there are so many vehicles, particularly auto, plying without having any permit. Now they admitted in their report, leaving aside all other aspects, if I put this question to myself, then nothing remains in the writ petition. That should be stopped. That should be stopped. The prayer is a notification issued in the year of 2023. Now they are saying that they will regularize. Page 23, my lord. I'm page number, my lord. Sorry, not 23. It starts from page 16.
Page 50 is your notification? 4th May notification?
No, no, আমাদের petition to page 16 to. Page 16, my lord, that is our prayer. Prayer starts from page 16.
So 16. 16.
16, my lord. My lord, this circular says that they will regularize.
16 is the prayer. Yes.
Yes, prayer.
Yes, and the circular says it will regularize. The one which you've challenged.
Yes, that cannot be. The mere issuance of a, my lord, it cannot redundant the provision of Motor Vehicles Act. Now the report says, yes, correct. Even, my lord, 2000, assuming for sake of argument, that they have issued the memo 223, that is valid.
Propose to make your submissions without the rejoinder?
Yes.
Very good.
Sir, কি করে মক্কেল তো অ্যাক্সিডেন্টে পড়ে আছে
Where is the bar under the Motor Vehicles Act?
My lord?
Regularize. Where is the bar under the Motor Vehicles Act?
Because of the Motor Vehicles Act, your lordship kindly see.
Provision, please tell me.
Yes, yes.
Please show me.
Now, suppose your lordship is well aware about the Garden Reach incident building. A recent writ petition I have filed, a provision was incorporated by the Calcutta Municipal Corporation to regulate certain unauthorized construction, certain cases. The absolutely not alter this. Now they no good of use to incorporate the provision for obtaining sanction.
That is a different matter altogether.
Yeah, no doubt, no doubt. It goes without saying. Just I cite an example.
But these autos are already running, already flying.
They have admitted. Not only that, my lord, they have say, concern RTS say, they have considered 23 memo. 2023 memo, on the basis of them, those stakeholders, they are flying their unauthorized vehicle, ask them to regularize the same. Only 40.
The issue is, how are you affected personally?
Because of the reason, I am flying my auto.
You are flying in which route?
My lord, I am flying.
Is that route covered by the notification?
My lord?
Is that route covered by the notification?
Yes, my lord.
Time, please show me.
My lord, Baguihati's Ultaranga station.
It's a public interest litigation, isn't it?
No. This is not.
How is your personal interest affected?
Because of the particular route that is from Ultodanga to Baguihati. Now, suppose my lord, allotted route is suppose 20. Now, if 100 vehicle is flying, then my business where?
What is your allotted route?
My allotted route is
Find it in the writ petition. It is at which
paragraph?
Your allotted route?
Paragraph, my lord. Paragraph টা Just a minute, my lord.
Yes.
Now, my lord. Page bolo. My lord, kindly see page 20. Page 20.
Page
My lord, page 20.
20, yes.
Page 20 onwards, our permit.
Subhash Dhar,
My lord,
20, page 20 is a permit issued in favor of Subhash Dhar. He is not a petitioner.
what's the order petition? My lord, kindly bear. What's the petition?
Not the repetition.
আচ্ছা ঠিক আছে সুভাষ দত্তরা কত আছে উজ্জ্বল ভদ্র আই এম সরি ম্যাডাম কেন আছে
That's what the matter. May I submit to one thing? First of all, matter. বোধ
হ্যাঁ
তুমি বলবে
বলুন আপনি কি বলছেন আমি ততক্ষণ খুঁজে নিই আমি তো ফার্স্ট টাইম অ্যাপিয়ার করছি আপনি
First of all, my lord, he is try to restrain the restrain the operator who are obtained permit on the basis of the notification issued by the transport department government. My lord, I am cut short the matter without finishing matter. One public interest litigation was filed. Honorable Chief Justice. My lord, Honorable Chief Justice was used to direct, but it is challenging this. Lordship directly shall not entertain. So the government notification.
What is the fate of that public interest litigation? What I got right now. Very good. Let me go through it. I will come back. Let me first time Mr. Devra handed over.
Another thing, my lord, another thing is, my lord, regarding his duties concerned. I am categorically stated that no permit has been issued in respect of this. Lordship kindly turn to my report.
Very well, Mr. Devra. Let me go through it. I will come back.
Required at all because the same notice has been dealt with in the public interest.
Very well.
Let him come.
Let me come back.
Yes.
Don't compel me. You are a privileged class. I know you are a state.
Let him
Kindly allow me.
come.
Please, sir.
7th May.
My lord. না দেবো না দেখো কেমন
By the
তোমায় জেরক্স করে দিচ্ছি তুমি কোথায় বসে
District Magistrate North 24 Parganas, Barashat.
এটা জেরক্স করে দেবো তো পল্টুদা বা পল্টুদা জুনিয়র
May 2023 is assailed in the writ petition. Paragraph, learned counsel for the respondents produces a copy of order passed in
এই প্রথম অ্যাপিয়ার বললাম পল্টুদা
WPA within bracket P 482 of 2023 on 19th September 2023, which demonstrates that the Honorable Division Bench has dealt with the said notification in a public interest litigation. Paragraph, learned counsel for the petitioners seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 7th May. Next.
He is made an appearance before your lordship.
Yes.
I heard about your lordship from bar, Justice Ghosh, this and this, very patience hearing. Now, I told my junior prior that my
And you did not find me very patient today. Did it, Boshu?
this is
You did not find me very patient today, isn't it?
my lord. Right, my lord.
Please come back.
Lordship.
Next.
Hello, order is kept on the court.
Yes, let's take it.
Deep this.
এই পল্টু থেকে এটা জেরক্স করে দেবে।
তাহলে এটা জেরক্স করে দিয়ে
হ্যাঁ দিয়ে দেবে, আজকেই দিয়ে দেবে। না এখানে মামলা করে ইয়ে আছে, ঠিক আছে। প্রিপেয়ার হয়, প্রিপেয়ার।
Yes. Mr. Debra in this matter. A report was filed on the earlier date.
Exception also. Exception also.
Exception also.
Well, the only thing neither, none of the reports, exception also filed when from first report. None of the report says about the discrepancies, how it appears. Well, the discrepancy with regard to the notification by which the government says that the number of permits for the route number 8, AR8 in Howrah is 50. Now, by way of a application under section 6 of RTI, they afterward they specified that 22 has been granted, and the numbers of the vehicles also has been given there. Now, my lord, we made the applications in terms of an invitation that your lordship is already invitation. That is at page 63. Page 63. There they invited applications, and I have fallen. We are all fallen in category 3. Page 63.
Yes.
Now, the invitation is of 29th of May 2023. And the application has to be made by 20th of September 2023. This is the last line. Now, within that period, I made the application. And I am under group 3.
Yes.
So far as this part is concerned, no answers in the report itself. Now, second, my lord, this very peculiar, which my lord, I think, my lord, I must have to file an supplementary affidavit. But just I am placing only. I will file. Just your lordship kindly see this. So my clients have collected this. Your lordship kindly see. This is an offer letter. This is an offer letter. Now, your lordship kindly see the same route. Now, your lordship, when it has been issued and the applications when made, with reference to your, it starts from this line I am saying. With reference to your application number so and so dated 15th March 2024.
So after all this,
even the date by which one has to apply for in that category, that is of 20th September 2023. And the person applied long after that. And that is not, this is a fresh offer letter issued. And he is saying the 50 has been filled up. I have told at that point of time, they told that 22 and
they say.
22 has been granted, 50 is the
20
strength.
is the fleet strength,
50 is the
granted.
fleet strength, according to your lordship kindly see. According to that is that page.
RTI says 20 fleet, the notification says 50.
Notification says 50. And thereafter, they told that after this notification, they told that 22 has been filled up. So remaining part is 28. I have applied within the period by which they have to consider, by which they have to grant. That is my
Yes.
This is the prerogative. Now they have granted an offer letter even subsequent to the applications made in the said particular. Then how can it be? I shall place this by of an affidavit. Yes, ma'am.
So this is
I
relevant.
know, but this is very much relevant because these are all going on.
Let us tell you.
What my learned friend submitting, what my learned friend, the affidavit by way of an affidavit, the reports has been filed, and the affidavit signed by my lord, your lordship kindly see. The person who signed the affidavit, he is an administrative head of that.
Mr. Devra, please take instructions on this. Let him come back with a supplementary affidavit. Please give him a copy so that he can.
I have handed over. I already handed over. And supplementary affidavit we handed over.
How can this be done?
How can it be done?
Learned.
Why? It is
This
there in
application
petition.
is pending. An application which was made after the closing date has been allowed. How? The authority cannot do anything and everything.
This is completely erroneous, arbitrary, and everything has been done by them.
Not the change. It's only place.
How can he? No. In your my lord, in his report, he has told the 50 has already been filled up. 50 has been filled up. Your report has been said. Then how this is assuming if it is then out of 50, 51.
The last date of submission of application was 20th September 2023. This is much after that. How was this considered?
24th of March,
The authority has to
2024.
explain, yes.
March 2020 this year. And my lord, this March.
Pending.
And my lord, March 2024 means last month.
Situation is very bad, Mr. Devroy. Please come back with instructions. Everything extraneous. Nothing happens on record.
This is completely colorable exercise of the my lord, administrative power, your lordship.
Please come back with your supplementary. On prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, let the matter appear under the same heading on 17th May. Please serve an advance copy.
Fine.
Small, there is a small matter. There is a food court table. Let me call the next matter. Let me see.
Somebody. This is also my matter. Let it be on Monday because let's see.
So I'm not calling. It will take some time, as miss. So I'm not calling further matters.
Monday.